With the consent of the other side, Lordship, I beg to mention item number 9, Lordship. Lordship, the matter may be fixed on 3rd of April, Lordship, in admission column for hearing.
Learned Counsel, Mr.
AU Ahmed.
AU Ahmed, 13, item number 13.
No, 9.
With the consent of the other side has prayed for adjournment, list the matter on when do you want?
3rd April.
3rd April.
Oh,
Yes.
May please the Lordship. Lordship, I beg to mention item number 12, my lord.
Hmm.
My lord, on 7/3/2025, there is an examination of witness took place. I am playing Lordship, I kindly call for the same, and I also obtain the certificate copy, my lord, and place before this honorable court. Can it be taken up on 17?
Learned Counsel, Mr. M. Ahmed, no?
M.
M. A.
Chaudhary.
Chaudhary has prayed for adjournment. And what was the other submission?
My lord, and witnesses, examination of witness took place on last Friday.
Okay, okay. Also call for the deposition, scan copies of the depositions of the witnesses and deposition recorded so far. List the matter on
17th, my lord, next Monday, my lord. Sir, deeply obliged, my lord.
May please, Lordship.
Hmm.
But I beg to mention item number 30, my lord.
Hmm.
My friend is for the respondents. This matter may be adjourned for 2 weeks, but 3-0.
Both sides are
Both
present.
sides, my lord.
Is agreed by the learned counsel for both the sides. List the matter on
My lord,
after
list
3
2
weeks.
2 weeks.
2 weeks.
Grateful, my lord. Look, similar prayer for item number 21, my lord. Here it's an admission matter, my lord. I'm for the appellant. This
Hmm.
matter may be adjourned for the day. my lord.
They've taken the consent of the other side.
Nobody is appearing, my lord. It's an order for rule
Okay,
11.
okay, okay. All right. Order 41 rule
Rule 11.
11. Okay. Caveat? No.
No.
Learned counsel, Mr. B. Kaushik has prayed for adjournment. List the matter. When do you want?
Can it be on 17th of March?
On 17th of March.
Grateful, my lord. All right.
Wait, please, your lordship. Lordship, I beg to mention item number 19, lordship. The one where CD not received, my lord. I'm on interim, my lord.
CDS call for is not received. Issue reminder. List the matter on. Interim order shall remain in force till then.
Obliged, my lord.
May it please your lordship. Lordship, I beg to mention item number 40, lordship. 40. Lordship, the matter may be adjourned for the day, lordship.
Learned
Consent
have you taken the consent of
Consent has been taken, lordship.
learned as agreed by the learned counsel for both the sides. List the matter after
20, 23, 20,
20.
20. 24th of March.
24th of March.
May it please your lordship. Lordship, I beg to mention item number 18, lordship. It is not available.
CDS call for is not received. Issue reminder. List the matter on. Are you on interim day?
No.
Short date.
18, can it be 18? Apply.
I have just mentioned item number 9, Lordship. With interim order is there, it may be continued.
Interim order shall
Item
remain in
number 9.
force till the next date of listing.
Item 1.
সেইটো zero, কিমানো দিয়া আছে zero?
May it please your lordship.
ঠাণ্ডা লাগিছে।
This is an application under section 483 PNSS. Petitioner is behind the bar for more than a year. Charge sheet has been filed. And charge payment for the last 6 months, they are not.
NDPS.
NDPS.
We'll call for the scan copies of the
Scan
records.
Whether it is required, because I am basing on 2 grounds, your lordship. First is that lordship knows that the violation at the time made at arrest by not furnishing the grounds of arrest, which the Honorable Supreme Court has held that it is a mandatory requirement. And once it is established that at the time of arrest,
We'll need the CD to know if there any rights have been violated.
Records has to be.
whether that will be required, because what they have furnished, I have annexed. They have issued a notice under section 50 and they have issued an arrest memo. But nowhere it is stated that there is any grounds of arrest to why I have been arrested, which is a mandatory requirement. What else it is required in this?
We'll get to know from the CD, I think. Call for the scan copies of the trial court record along with the scan copies of the CD. List the matter on
20 March.
Like,
Item 2.
I think relating to POXO as well as in the affair. So matter may be
Yes.
fixed for CD.
Learned counsel, Mr.
MDMS Ali.
MD
MS Ali.
Mr. MD MS Ali is present for the
Petition.
for the petitioner, learned additional PP. Ms. S.H. Bora is present for the respondent number 1.
Yes.
For the respondent state, for the respondent state, petitioner takes steps to issue notice to the respondent number 2, returnable within 4 weeks. Oh, returnable on 25th of March.
25th.
Meanwhile, call for the Sashi has not been submitted.
ma'am.
No? Call for the CD.
Highly approved.
Item 3,
It's a NDPS mallet in between diary may be possible.
Investigation.
Investigation.
Call for the CD. List the matter on.
18 or 19.
19 March.
I am obliged.
Item 4,
May I please your lordship? Lordship, it's an NDPS case, my lordship, charge sheeted case, my lordship. My lordship, I'd like to trouble your lordship to kindly see page number 47, my lordship. There's a forwarding report, my lordship.
NDPS charge sheet
NDPS, my
case.
lordship, charge sheeted case, my lordship. Co-accused has not mentioned my name, my lordship. I have also annexed the
We'll
co-accused.
need the scan copy.
Absolutely, my lordship. My lordship, this petitioner is involved in 2 cases, my lordship.
They're
Uh,
better.
Yes,
The
my lordship.
more we'll need the
Exactly, my lordship. So both the records may be called for, my lordship. And
Okay.
the another matter is fixed on my lordship on 20th of March, my lordship.
call for the scan copies of the trial court record along with the scan copies of the CD. List the matter on 20 March along with
Along with my lord bail application number 643-2025, my lordship. And the scan copy of both the cases, my lordship. PS case number 90 and PS case number 99.
But that case, I think it has been called. In the
Yes, my
other
lord.
case, it has already been listed, so I believe it has been called
Yes, my lordship. Call for
On 20th, okay?
20 March.
20 March.
20.
Item 5,
Highly obliged, my lord.
item 5,
May I please, your lordship? Lordship, case there is necessary, it's a POCSO matter. And
Learned counsel, Mr.
PP Botakur.
PP Bora is present for the petitioner and learned additional PP. Ms. S.S. Bora is present for the respondent state. Petitioner to take steps to issue notice to the respondent number 2. Respondent number 2 returnable on date.
26 March.
Meanwhile, call for the CD.
Yes, sir.
Yes, there is necessary.
Meanwhile, call
I
for the
have
CD.
another prayer, my lord. For a moment, if your lordship peruse page number 21 is the FIR. In page number 22, the informant mentioned her address as Upper Katani Gaon, Majuli Zilla. This is the only address. She has even not mentioned her husband name also. And no post office, nothing. And when we found in the internet, maybe Upper Katani Gaon is in Kamalabari area. But the thing is that for a moment, if your lordship peruse the order, rejected order passed by the unlearned sessions judge, Your Honor, in the third portion, may I read for a moment, a small paragraph, Your Honor.
You want the address?
When the informant
Something
received
is
a
wrong with the
notice,
address.
yes, the thing is that here it is mentioned that the when the informant received a notice to register an objection to the accused bail petition, she informed the learned special PP over phone that she will not able to appear before the court due to illness of her minor daughter and she resides at Morigaon. In the FIR it is Majuli, here it is Morigaon.
If we cannot if you cannot serve this notice in the address given now, then we will through the district judge, because the district judge.
Alternatively, may I pray one thing, Your Honor? I will issue notice in this address, Kamalabari address, and alternatively, if your lordship allow that
No,
the
not
notice
now.
may be served through the investigating officer. A report may be submitted because they definitely
Yes,
use
yes,
in
can allow.
yes.
Mm.
The
Through the no notice to the investigating officer.
As per notification 17, usually it goes to registry, then it comes to our office, then we serve it through concerned.
Why to the investigating officer? Concerned OC, to the OC.
Yes.
Notice can also, notice to be issued to the OC of the concerned PS is permitted.
Yes, and a report may be submitted, service of notice may be reported.
That will be submitted.
Obliged, Lord.
item 6,
May I please, your lordship? See, also NDPS matter, my lord.
Hmm.
And this says LCR may be called for, my lord. Scan copy.
Call for the scan copies of the trial court record along with the scan copies of the CD, list the matter on.
7th March.
My lord, special judge NDPS Kamrup Metro. Yes,
Shorter date.
my lord.
You want a shorter date?
No, yes, my lord. And LCR may be called for from the special judge.
No,
And-
that will be called for
24th March.
24th
Okay.
March.
I'm obliged.
Item 7.
May it please your lordship, my lord. This is an application for pre-arrest bail filed under section 482 of the BNSS. Now, my lord, in this case, there was an FIR in regard to recovery of narcotics substances. Then, my lord, in a seizure list is there, my lord, charge sheet submitted,
Mm.
trial comments.
Mm.
Now, so far the FIR charge sheet and or even in any of the statement of the witness, my name doesn't reflect.
Mm.
Neither I have been shown as an absconder also.
You want a interim protection?
Yes.
Why? On what ground?
My lord, why? Because now police is calling me to the station because my name in the charge sheet, one of the witnesses who is a murder accused, and I have deposed against him in the court. He has said that money, whereas that is not my name also, my lord, but some people in my locality known as money. He has now trying to implicate me in this case, or I don't know, he's forcing the police to summon me in this case. At the moment, my lord, I am also undergoing, my two children who are suffering from thalassemia are undergoing treatment outside the state. And I am with them. I want to come and cooperate with the investigation why they are.
Let us call for the records
My lord, your lordship will kindly.
within a short date.
Your lordship will kindly.
We will grant you whatever relief you want for treatment of your children and everything. We will grant those reliefs. But meanwhile, let us call for those records.
Then may I pray on 20th, my lord, of this month,
20th.
20.
Call for the charge sheet has been submitted.
Yes, sir.
We have annexed all the copies only. I don't think, my lord, the only one witness have been examined, but because no purpose will be served to, they can go through the documents, my lord, because scan copy is not required because I have given your lordship in the size
Have
of
you
the
given the scan copies of the CD?
CD to.
Sometimes CD is required. Let us call for the scan copies of the trial court record along with the scan copies of the CD. List the matter on short date and idiot. 20th March.
We are blessed. On that day, my lord, your lordship will observe.
Of course.
Item number 8 for admission.
May I please, your lordship, regarding item number 6, my lord, there is a small correction, my lord.
Hmm.
There, I wrongly, it was written, my lord, additional session just 3. It should be special just NDPS 3 in my first item. I may be allowed to correct that portion.
You will have to give an amendment cost title. Amended cost title.
Only instead of additional 3, there should be, my lord, a special just NDPS. That part, my lord.
You try your luck with the registry, but there is a notification. I think you will have to give a amended cost title. You approach the registry. There's a notified order. You'll have to submit an amended cost title. You can approach the registry. You can
Right.
correct it.
My lord, I'm obliged.
Item number 8 for admission.
রক্ষী থৈ থাকো নেকি নেকি কৰিয়ে নেকি কমাণ্ডাৰী 10:45 অলপ দেৰি ৰখিব পাৰি
Item 10.
My pleasure. And this is an application under Article 227 of the Indian Constitution, Lordship. Here, the learned civil judge senior division number 3 rejected my annexer 3 application. That is an application under Order 6 Rule 70 filed by the plaintiff side, Lordship, to correct only typographical error. Before coming to impugn order, if your honor kindly peruse annexer 3, my amendment application, your Lordship, at page 35.
You have any objection?
Yeah, do we have objection here?
You have objection.
Yes.
It's a just
Are you prepared?
typographical error.
Yes, sir.
Okay. Page 35.
Page 35, Lordship, annexer 3. Suit for Lordship, declaration of right title interest over Schedule F property
Hmm.
and the recovery of possession of a part of Schedule F that I have described in Schedule L and a permanent injunction. If your honor kindly peruse my prayer before learned trial court at page 36, Roman 1 and Roman 2.
Hmm.
In prayer person, Lordship, in prayer number B, in the plan, the word principal defendant 1 and 2 may be corrected as principal defendant number 1, 2, 3. And similarly, in prayer number C, also principal defendant number 1 and 2 may be corrected as principal defendant number 1, 2, 3.
So at which stage you have filed this application? At which
At
stage?
at the stage of PW, Lordship.
At the stage of before trial has commenced.
Exactly, Lordship. And Your Honor, second, Your Honor, Roman 2, in third line of paragraph 12 of the plan, the word schedule F, E and F may be corrected as schedule F and G. Lordship, before coming to impugn order, if Your Honor kindly peruse plan first, Annexer 1, page 10.
Page 10.
Page 10. There's suit between brother and sister, Lordship. Here, Mohesh Medhi was the plaintiff who here pleaded Jitu Kumar Medhi, Sarojini Medhi, and Prabhat Medhi as principal defendant number 3. And other two brothers, that is Sandra Medhi and Uma Medhi, as pro forma defendant, here, Lordship. Here, if Your Honor kindly peruse my prayer person at paragraph 9, page 19, prayer number A decree of declaration of right title interest of the plaintiff over Schedule F property. Here, correction is required in prayer number B, recovery of possession of Schedule L being part of Schedule F land by removing, dismantling all kind of structure raised by the principal defendant number 1 and 2. It ought to have been, Lordship, I have thought, I have implemented 3 defendant as principal defendant number 3 and other 2 and pro forma defendant number 3, 4 and 5. Lordship knows very well, I have implemented principal defendant number 1, 2 and 3 as I have aggrieved by some works done against the plaintiff, Your Honor, in respect of Schedule F property. That is why I have also implemented that pro forma one brother, that is namely Lordship Prabhat Medhi as principal defendant number 3. Here in prayer number D, Lordship, due to typographical error, I have mentioned as pro forma principal defendant number 1 and 2 instead of principal defendant number 1, 2 and 3. And Your Honor, in next prayer, prayer number 3, permanent injunction restraining the principal defendant number 1 and 2, that similar mistake. It ought to have been principal defendant number 1, 2, 3. Now, what happened, Your Honor? The learned trial court, while passed the impugn order, that is, the Lordship will find at Annexer 5. Annexer 5 and effective court, paragraph 6, page 47. May I read, Lordship?
Yes, yes.
Paragraph 6. Upon hearing and perusal, it appears that in paragraph 13 of the plaintiff alleged that the principal defendant number 1 and 2, in collusion with defendant number 3, occupied the Schedule L land, which is part of Schedule F, and without any right title interest. The plaintiff has right title interest over Schedule F and G land as per their family settlement. And as such, the plaintiff has right for possession over the said Schedule F and G land. Thus, the plaintiff instituted the instant suit with a prior right title interest over Schedule F and recovery of possession of Schedule L, which is part of Schedule F, and by removing the structure made by the defendant number 1 and 2. Thus, it appears that the averment made in the plan by the plaintiff is with respect to Schedule defendant number 1 and 2 only, in connection with Schedule F land. If prayer of the plaintiff petitioner is allowed to insert the proposed amendment mentioned in paragraph 2 of the petition by including the principal defendant number 3, the prayer number B would change the nature and features of the instant suit. Thus, there is inconsistency in the petition made by the plaintiff petitioner and the amendment made in the plan. The proposed amendment in the plan, if granted, will raise inconsistency plea. Now, whether my plan, the statement made in the plan, Your Honor, will cause raise inconsistency, please kindly peruse some paragraph in my plan, Your Honor. If Your Honor kindly peruse page number 14, annexure 1, internal page 5. Here, Your Honor will find the share of the brothers. Your Honor, original schedule A and B, A1 and A2, Your Honor, they are in ancestral property. After oral partition, if Your Honor kindly peruse in column number 3, schedule F. Schedule F. That is here is the subject matter before learner trial court. Out of that schedule F property, I have been dispossessed from 3 katha of land. Here, so total land was in schedule F lordship 4 katha. Out of that, I have dispossessed from 3 katha from schedule F. Then kindly, if Your Honor kindly peruse paragraph 13, page 17. Married lordship.
Yes.
That the plaintiff begs to submit that he is the absolute owner of Schedule A land, being part of Schedule F land, on the basis of amicable partition arrived between him and his other brothers. Therefore, being absolute owner, he has exclusive right title interest over the same. However, the principal defendant number 1 and 2, who did not have right title interest over Schedule A land, in collusion with defendant number 3, illegally occupied the same by dispossessing the plaintiff therefrom. Here I have made specific allegation that principal defendant number 1 and 2, in collusion with defendant number 3, dispossess us. This is clear statement is there. Then, Your Honor, it is pertinent to mention here in that as per petition of the predecessor of the defendant number 1 and 2, Bhagavan Medi, got 4 katha of land in schedule F, schedule E land. But at present, the defendant number 1 and 2 occupying about 5 katha 15 lesses of land, and similarly, defendant number 3 got 4 katha of land in schedule D, but at present, the defendant number 3 occupying 5 katha 5 lesses of land. That means, Your Honor, as per that oral petition, that Bhagavan Medi, the predecessor of the principal defendant number 1 and 2, got 4 katha of land. But by dispossessing the plaintiff, now his occupation 5 katha 15 lesser. That means 1 katha 15 lesser more. And similarly, Lordship, next part, defendant number 3 also got 4 katha of land. But after dispossessing the plaintiff, now he is occupying 5 katha 5 lesser. That means 1 katha 5 lesser more.
You can sit down.
1 katha 5 lesser more. The principal defendant number 1 occupying 1 katha 15 lesser more than his share, and defendant number 3 occupying 1 katha 5 lesser. That means 3 katha, Lordship. That exactly I have described in schedule L, Lordship. So specific allegations is there against defendant number 1 and 2.
So this paragraph is okay except in the prayer portion and in the plain portion, in the cost title.
Yes, Lordship.
Okay.
Prayer person and paragraph number.
But the sum and substance in the plain is similar to your new amendment prayer.
Yes, Lordship. Yes, Lordship. That is why here the learned trial court, while discuss
Change the nature of the suit.
change the nature of the suit. And here also it has discussed that the I have made allegation only against defendant number 1 and 2. No allegation is there specific against principal defendant number 3. Therefore, in the event of allowing that amendment prayer, the nature of the prayer will be changed. That is not true, Lordship. your lordship knows very well, pleading is to read as a whole. Here, specific allegation is there regarding disposition of the plaintiff by the defendant number
So
1
this
and
is
2.
only on the prayer of admission,
Yes, lordship.
only admission. Yes, any objection? Can we admit it?
Lordship, it
I
can
will
be
admit and
disposed of
proceed for hearing, or you want this to be disposed at the stage of
today
admission?
itself.
The
Just
amendment petition was filed after 3 years.
No, but it
Let us
was
say-
filed before evidence of PWs have been recorded.
Yes, madam, but
But
they.
evidence, evidence have been submitted
Yes,
before
yes.
affidavit has been submitted.
My lord.
It was filed. So there,
Trial has not been commenced.
according to the code, you can before before the commencement of trial.
But amendment. out of the February 7th.
Only I am asking
No,
if there is
My lordship,
very
before
strong resistance, then we will finish it today. But if we can admit it, then maybe we can admit it
My lordship-
for and fix it for hearing.
Yes, my.
Hmm.
the
Admit and
petition
fix it for hearing.
Yes.
Lordship, it can be disposed of as very minor.
Minor issue.
Yes,
My lordship, they want.
Yes,
to
can be disposed of.
yes, lordship.
change the schedule E and F. They admitted that they are owner of the F and G.
Hmm.
Now, para 12, they say it's E and F. Now they want to change to F and G to E and F.
No, I will show.
That is
If
the-
you honor
that is-
kindly allow me to finish
This
my
we have
part.
Already, my lordship,
My part
filed a written statement. Issue has been framed. Now, if amendment allowed, then again I will have to file a
Additional
written
issues. Huh?
Additional
Written
written statements
statement,
with
yes.
this.
But that can be
But that
allowed.
is the contradiction, because last
can
3
be
years
allowed.
they are contesting the case before the trial court. But they did not even pointed out the particular mistake.
But last 3 years, you see what took so long
Yes,
that even evidence has not progressed.
Yes,
Lordship,
Even
suit
though-
was filed in the year 19, thereafter COVID, lordship, due to COVID, up to 22 February. No effective order were passed, lordship, and immediately on 8/5/2023.
Okay, then we will we will complete the hearing today then.
Yes.
If you think it is a minor issue,
Yes, sir.
which he doesn't think, but by the way. Jabo para. Yes, you can complete your hearing. We can proceed for disposal of this at the stage of admission.
Yes, sir.
Yes, you can complete your hearing.
Then, Your Honor, paragraph 13 of the plan, page 17. That
Yes,
this
yes.
statement.
You have
it's-
read it. Paragraph 13, entire paragraph you have
yes,
read it.
Yes, I have read it. Yes, this statement itself reveals there is a clear allegation against the defendant number 1 and 2 regarding disposition of the plaintiff from 1 kata 15 lesses of land. Accordingly, the plaintiff also alleged against defendant number 3 regarding his disposition from 1 kata 5 lesser. That is total 3 kata of land that I have described in Schedule L.
F.
Then
F or L.
F, lordship.
Mm.
F is total measuring 4 kata.
Mm.
Out of that,
Out
I
of
have
3
disposed
katas.
from 3 kata
Mm.
that I have described in Schedule L.
Mm.
Then, if you want to kindly peruse next paragraph 14.
Mm.
That plaintiff begs to submit that he is being absolute owner, have all kind of right title interest over Schedule F land, along with Schedule G land and B land. G land is another part. Here, G land is not disputed, and B land, Schedule B land purchased from the predecessor of the defendant number 1 and 2 by way of registered sale deed. That is also not disputed. Here before the learned trial court, lordship. But the defendant number 1 and 2, after dispossessing the plaintiff in collusion with defendant number 3 from a part of Schedule F land on 9/3/2019, now making boundary wall with an intention to change the nature and character of the land. Here, plaintiff also made specific allegation against the principal defendant number 1, 2, and 3. Here, another
No,
part.
there, I think there they do not have any objection relating to 1, 2, and 3. Do you have any objection relating to inserting the name of 3 also? There, I think they do not have any objection.
Then,
1, 2,
Your
and
Honor,
3.
Simply, I would like to say, Mr. Lordship,
It's a due to clerical mistake and typical mistake, that particular tree not included in the.
Yes,
draft.
yes.
Their submission, but the
Mm.
clerical mistake, if there is a clerical mistake, there should be a name in their particular place, that's 1 to 4. Then there is a clerical mistake because 4 is included instead of 3. So no, nothing, only for pair is for 1. So
Mm.
how it can be a clerical mistake?
In the event of non-implementing the principal defendant number 3 in the prior portion, I will not get recovery of possession from 1/5 acres of land. Because as per statement made in paragraph 13, Lordship, defendant number 3 is in possession 5/5 acres instead of 4 kotha. That is 1/5 acres is more. By dispossessing the plaintiff, if the defendant number 3 is not incorporated in the prior portion, Lordship, I will not get relief, specifically recovery of possession from of schedule L and Lordship. So I need basically, as per statement made in the plan, I need recovery of possession 1/15 acres of land from defendant number 1 and 2, and 1/5 acres of land from defendant number 3. This is very much apparent from paragraph 13 of the plan. That is why insertion of the correction of the defendant number 1, 2, 3 in place of 1 and 2 is very much required, specifically to get recovery of possession, Lordship. Then another correction, typographical mistake is there in the paragraph 12 of the plan. If your Lordship kindly peruse
Yes.
paragraph 16, paragraph 12.
Yes.
Here, the plaintiff begs to submit that he has been residing over Schedule B land with his family since 2009, which is about 180 to 200 meters away from the Schedule F, E and F land. Here it ought to have been Schedule F and G land. Because my prayer here in the plan, Lordship, I have specifically mentioned that as per oral petition, as I quoted in paragraph page 14, Schedule F and Schedule G is the share of the plaintiff, Lordship, as per that oral petition. So in other part of my plan, Lordship, I have categorically stated that the plaintiff has right title interest over Schedule F and G land. It is repeatedly, there's repeated statement is there in the plan. Here, due to typographical error, Lordship, in paragraph 2, I have mentioned as Schedule F, E and F instead of Schedule F and G. And in this regard, Lordship, the defendant who filed written statement, Lordship will find in paragraph 28, page number internal page 3. Last 3 line. First paragraph, last 3 line. Here,
In the written statement,
written statement.
page,
In page 28, internal page 3.
Hmm.
The defendant denied my title over Schedule F land in last 3 lines.
last 3 lines, okay.
Yes, specifically denied. That is why dispute arose. Then
No, the where, which page?
last 3 lines. There is no Schedule F
Last
plot
3
of
lines,
land.
paragraph 12,
Paragraph 10,
10, okay.
page 3.
Yes, yes.
There is no Schedule F plot of land within the boundaries as mentioned in Schedule F of the plan. The Schedule F plot of land is not identifiable. That means they denied it. That is why issue framed, Lordship. Then, Your Honor, paragraph 29. Page 29, paragraph 13.
Paragraph 13, yes.
Your paragraph 13, it is, Lordship, in this regard, the statement made in paragraph 9, it is stated that the plaintiff has wrongfully claimed Schedule F and G plot of land measuring 5 katha plus 4 katha, that is 9 katha. They have also knows very well that the dispute property is Schedule F and G. They repeatedly denied. And in the same paragraph, page number 30, Lordship will find after 6 line, the plaintiff has wrongfully claimed 9 katha land alone in Dag number 864, Schedule F and Schedule Z. So,
Which one, which one? Page 30, which line?
page 30
Ah,
from line 6th.
sixth
up
line
top.
from top. Yes, yes.
The plaintiff has wrongfully claimed 9 katha land alone in Dag number 864, Schedule F and Schedule Z. Moreover, the boundaries mentioned in Schedule F, F schedule is wrong. So, defendant also replied with respect to Schedule F and Z
Hmm.
repeatedly in the written statement, Lordship. So, from that reply itself, it is apparent that I have wrongly mentioned in paragraph 12 as Schedule F, E and F instead of Schedule F and Z. So, Schedule F property is not disputed, Lordship. E property is not disputed, Lordship. Here, only disputed property is Schedule F and Z.
All right.
From those statements, it is apparent that the typographic in paragraph 2, the plaintiff made only typographical mistake. And that typographical mistake will not change the nature and character of the plant, Lordship, as per a statement made in other part of the plant.
Yes.
Then, if you honor kindly, Lordship kindly peruse impugn order, page 48,
Hmm.
paragraph 7.
Yes.
Married Lordship.
Yes.
Moreover, it appears that the commencement of trial of the suit has started, which is now pending at the stage of PW, for which the petitioner has to show due diligence for the amendment, and in absence thereof, no amendment can be permitted. It appears that the proposed amendment was well within the knowledge of the plaintiff, and in spite of the same, it was not inserted in the plan at the time of filing the suit. Thus, the plaintiff, having failed to show due diligence and having regard to the nature of proviso to Order 6 Rule 17, the proposed amendment could not be permitted at this stage. Now, kindly peruse my annexure 3, whether in my application due diligence is the statement regarding due diligence is available or not. If you honor, kindly peruse page 37, paragraph 4. Married Lordship.
Hmm.
That the plaintiff petitioner begs to submit that he is now a senior citizen and he has been suffering from various age-related ailments since last 2-3 years. Under such circumstances, the plaintiff was physically not in a position to cooperate his counsel at earlier stage of the suit. However, soon after coming to know about those unintentional typographical clerical error, the plaintiff has immediately filed this application before Your Honor. Under such circumstances, the plaintiff petitioner, in spite of his due diligence, could not file this application at earlier stage of the suit. But unfortunately, the learned trial court did not consider that statement.
All right.
In this regard, Lordship, the suit was at the stage of PW. Whether when trial commenced in this regard, the Honorable Supreme Court in two decision, Lordship, it is categorically held that trial commenced when evidence is filed. First,
Hmm.
Lordship, kindly peruse Baldev Singh,
Hmm.
page 9.
Yes.
A person is highlighted in page 9, Lordship.
Yes.
Married. Uh, Before we part this order, we may also notice that the proviso to Order 6 Rule 17 of CPC provides that amendment of the pleading shall not be allowed when the trial of the suit has already commenced. For this reason, we have examined the record and find it. In fact, the trial has not commenced. It appears from the record that the parties have yet to file their documentary evidence in the suit. From the record, it also appears that the suit was not on the verge of the conclusion as found by the High Court and Trial Court. That apart commencement of trial as used in proviso to Order 6 Rule 17 in the Code of Civil Procedure must be understood in the limited sense as meaning the final hearing of the suit, examination of witness, filing of document, and addressing the of argument. Here in my suit, Lordship, suit at the stage of PW. So as per this judgment, trial is not commenced. Then, if Your Honor kindly peruse next judgment, Bidda 5,
Hmm.
paragraph 12.
Yes.
Here highlighted, Lordship, that apart commencement of trial as used in proviso to Order 6 Rule 17 of the Code of Civil Procedure must be understood in limited sense as meaning the final hearing of the suit, examination of witness, filing of document, and addressing of argument. In both judgment, Lordship, the Honorable Supreme Court categorically held that trial commences when evidence is filed.
Hmm.
Then, Your Honor, whether even if assume that I have not explained in my petition regarding due diligence, that is available in paragraph 2. Already I have read out. In this regard, the Honorable Supreme Court held that in 3 judgment, Lordship. If Lordship kindly peruse first Pithani and others.
Hmm.
Paragraph 14, Lordship.
Yes. Yes.
Only highlighted person.
Hmm.
Order 6 Rule 17 CPC postulates amendment of pleading at any stage of the proceeding. In Pirgona Anganda Patil versus Kalgonda Sigonda Patil and others, which still hold the field. It was held that all amendment ought to have been allowed, which satisfies the two conditions. A, of not working injustice to the other side, and of being necessary for the purpose of determining the question in controversy between the parties. Here, in this suit, Lordship, this amendment was allowed at very last stage of the trial, Lordship. Here, the basic principle laid down, Lordship, whether the other party will cause any injustice due to that amendment. Definitely not, Lordship. In fact, I need not to file fresh amendment plan. It can be corrected by the bench assistant of the court, Lordship. And secondly, Your Honor, whether that is necessary for determining real controversy between the parties. Of course, Lordship. Here I have sought recovery of possession in respect of Schedule L property, Your Honor, which is part of the Schedule F. So in the event of non-correcting that prior person, I will not get relief for recovery of possession, specifically 1 kata 5 places of land from principal defendant number 3. Lordship. Then,
Yes.
if your Lordship kindly peruse Mahila Ramkali Devi,
Hmm.
paragraph 20, Lordship.
Hmm.
Married, Lordship.
Yes.
It is well settled that the rule of procedure are intended to be handmaid of administration of justice. A party cannot be refused just relief merely because of some mistake, negligence, inadvertence, and even infraction of rules of procedure. The court always gives relief to amend the pleading of the party unless it is satisfied that the party applying was acting mala fide or that by the blunder he had caused injury to the opponent which cannot be compensated for by an order of court. Here, this lordship amendment also allowed by the Honorable Supreme Court at belated stage, lordship, after commencement of trial. Here, lordship, it is held that I have no mala fide intention, lordship. It is apparent from the other statement of the plan, lordship, it is typographical error. And last judgment, lordship, Ramesh Kumar Agarwal,
Mhm.
your lordship kindly peruse paragraph 10 and 11.
Mhm.
In paragraph 10, in this judgment, the Honorable Supreme Court refer a judgment of 2009-10, page number 84, where the some factors were considered to dealing with amendment application, then effective for lordship at paragraph 11.
Mm.
It is clear that while deciding the application for amendment, ordinarily the court must not refuse bona fide, legitimate, honest, and necessary amendment and should never permit mala fide and dishonest amendment. The purpose and object of Order 6 Rule 17 is to allow either party to alter or amend his pleading in such manner and on such term as may be just. Amendment cannot be claimed as a matter of right and under all circumstances, but the court, while deciding such prayer, should not adopt a hyper-technical approach. Liberal approach should be a general rule, particularly in cases where the other side can be compensated with cost. Normally, amendments are allowed in pleading to avoid multiplicity of the litigation. Here, lordship, if I did not correct the prior person, then I will have to file another suit against defendant number 3, lordship, for getting recovery of possession. In this circumstances, lordship, the trial court apparently made mistake in considering all aspects available in the plan as well as regarding a statement regarding due diligence. The plan itself reveals that there is a typographical mistake. So this due to correction of this typographical mistake, Your Honor, the nature and character will definitely not change, as held by law and the trial court. So interference under Article 227 is required, that may be.
Well, so my submission is that due diligence not explained properly in the amendment petition. As well as the schedule as stated in the schedule of the suit, Your Honor. This is making schedule. No legal partition was made between the parties till date. He himself admitted the fact in the suit here. Now, he claiming the F and G is his possession and he inherited the property F and G. Now in paragraph 12 he said E and F. Now he want to amend the paragraph 12 to EFN to FNC. Go ahead and file the written statement. My lord, that is this contradiction. So my lord, in the belated stage is coming and filing an amendment petition.
This is not belated stage.
My lord,
Trial has not yet commenced.
yes, my lord, but they're taking time filing the evidence and
They
everything.
have taken time, yes.
Yeah.
They have taken time.
So my lord,
But he has afforded explanation that there was COVID in between.
yes, my lord. Then the other amendment regarding 1, 2, and 3. That is it's a clerical mistake or typographical mistake. But it is 1, 3 is that instead of 3 it should be 5 and 6 something to be there. That can be considered as a typical mistake. So instead of 3 it is entered is a 4. But he said due to typical mistake 3 is left out. Error and typical mistake is correction of the existing error, not to insert a new amendment. So, my lord, a humble submission. So, lordship that order passed with the trial court, rightly passed. So, lordship may appeal the order.
Lordship, only I want to have one thing. My plan itself crystallized, Lordship.
Where is the plate?
Page number 10, annexure 1. Here, 3 principal defendants are there. And other 2 brother implicated as pro forma defendant number
Oh.
4 and 5.
Oh.
So, Prabhat Medi was implicated as principal defendant number 3 due to that apprehension as explained in paragraph 30. So otherwise, he ought to have been implicated as pro forma, Lordship. That the structure of the plan itself says the necessity of principal defendant number 3 and the relief against him. So it will not change nature and not new implement. The plan itself crystallized.
This against this petition, have you filed any objection?
No, no,
No. No written objection.
No, Lord.
I'll dictate the order now. It will take some time.
Okay.
Around 5-10 minutes. If you want to wait, you can wait. It'll take some time, around 5-10 minutes. I'll dictate the order
I
now.
will.
No, you will have to wait. Or you can leave your junior and go. But others, I'm saying you can, if you have other cases, you can go to some other courts. It will take another 5-10 minutes.
My lordship, I am leaving
Yes, yes, sure.
for the other.
Yes, yes,
My lord.
yes. Heard Mr.
R. Ali, Lord.
R. Ali, learned counsel for the petitioner. You were the plaintiff. You were the plaintiff also.
Plaintiff, Lord.
Learned counsel for the petitioner, stroke plaintiff, Sri Mohesh Chandra Medi, who has filed this application under section 227 of the Constitution of India, challenging the order dated 9/7/2024 passed by the learned civil judge within bracket. ঠিক আছে না? লাহেকে ক'ব লাগে নেকি? অলপ লাহেকে অ'. Learned civil judge within bracket senior division, bracket close number 3, Kamrup, capital M within bracket at Guwahati in connection with mid-J case number 456 of 2023 arising out of title suit number 124 of 2024. Full stop. It is submitted that the petitioner as plaintiff preferred the title suit number 124 of 2019, comma, seeking a decree of declaration of right title and interest of Schedule F land, comma, recovery of possession of Schedule L land being part of Schedule
F.
F. It was of capital, huh? FL. Schedule F. Schedule to the episode at a heidi diba. Hyphen at a diba. Schedule F L and a equivalent hyphen at diba. Comma. And permanent injunction. And also permanent injunction, full stop. D nalage. Sri Jitu Kumar Medhi, Sri Sarojini Medhi, Srimoti, Sri Jitu Kumar Medhi, Srimoti Sarojini Medhi, and Sri Prabhat Medhi were arraigned as principal defendants, comma, whereas Sri Chandra Medhi and Sri Uma Meti were arraigned as pro forma defendants in the aforementioned title suit. Most of the defendants contested the defendants are contesting the title suit and they have submitted written statement. The defendants are also arraigned as respondents in this present petition. The petitioner is aggrieved by the order dated 9/7/2024 passed by the trial court as the petitioner's prayer for amendment of the plaint was dismissed. Amendment of the plaint was dismissed by the learned trial court.
Learned trial.
By the learned trial
Civil Judge
court.
Senior Division number 3.
Yes.
From the
Full stop. It is submitted that due to typographical error in the prayer numbers small b and small c of the plaint, comma, the engaged counsel erroneously mentioned as principal defendants number 1 and 3 instead of principal defendants number 1, 2, 3, 1A and D and 3A instead of 1, 2, 3 in the third line of paragraph 12 of the plaint, comma, in place of schedule -F and schedule -G. And in place to naলাগে হা এটু ইমানখিনিলৈকে লিখি পেলাই ফুল ষ্টপ দি দিবা হা in place of principals dependent number 1, 2, 3 full stop দি পেলাই বাকিখিনি কাটি দিয়া. It is further submitted that it has also been wrongly mentioned as
schedule E and F in place of F and G.
in para number 12
Para number 12, third line.
that in the third line of para number 12 of the plaint, comma, in place of schedule -F and schedule -G, it has been wrongly mentioned as schedule E and schedule F. It is submitted on behalf of the petitioner stroke plaintiff that the petitioner learned about the typographical error when he was preparing his evidence in chief on affidavit to be submitted before the learned trial court. Thereafter, immediately, the petitioner filed an application under Order 6, Rule 17 of the Code of Civil Procedure 1908 within bracket CPC for short bracket close for correction of the typographical error by way or amendment and this petition was registered as Miss J case number 456 of 2023. The respondents stroke defendants filed a written objection again in the Miss J case number 456 of 2023. It has been elaborately discussed in the petition, and reasons were assigned showing due diligence as to why the petitioner could not approach the trial court for correction of those type of the aforementioned typographical errors at the earlier stage of the case. Next prayer heard Mr. Kunasle MP Borwa, learned counsel for the respondents stroke defendants. 1A. Okay, respondent number 1, 2, 3. Respondent number 1, 2, 3. 1, 2, and 3. It is submitted by the learned counsel that the errors cannot be considered as typographical error. Full stop. An amendment of the plaintiff will change the nature and character of the suit, which is against the law. Full stop. It is submitted that the order impugned by the petitioner has been correctly passed by the learned trial court, and full stop. And the learned counsel for the respondents have prayed to dismiss the petition. I have considered the submissions at the bar with circumspection. AC to read pari niki? Central AC to itu off kori pele. Objection. It is further submitted by the learned counsel for the respondents that the petition for amendment of the plaint has been submitted at the belated stage after prolonged 3 years of dependency of the title suit. Etu he objection or tate kubat objection disile je Borwa learned counsel he tate kubata line of bridle hoise paragraph 2. The operative part of the order impugned by the petitioner is reflected herein below verbatim. Eto within inverted commas, moi eto heri blue tick di disu, page 47. Para 6, blue tick di disu, huh? Within inverted commas, italics or likhi diba. Para 7 no likhi diba, huh? But which paragraph you tried to show that the prayer is included in relating to schedule F and G of the land? You were showing that paragraph in the plain,
13 of the plan.
Huh?
13 lot.
paragraph 13 of the plain. Which page?
Page 17.
Page 17.
Correction, typographical error in paragraph 12, that is page 16.
It is submitted next, sir. It is submitted by the learned counsel for the petitioner that he is the absolute owner of Schedule L, land being part of Schedule F, on the basis of amicable partition between him and his brothers. Brothers, i.e. principal, the i.e. respondent number 1, 2, and 3, no?
All lots of pro forma defendant also, against defendant.
Oh. Okay. Nalage etu. And his brothers, full stop di dia. Bagi hin nalage. The defendant number, defendants hyphen, respondent number 1, 2, and 3, who did not have any right, title, and interest over the schedule L land in 1, 2, and 3, no, 1 and 2 likhi dia. 1 and 2, who did not have any right, title, interest over schedule L land, in collusion with defendant stroke respondent number 3, illegally occupied the aforementioned land, that is schedule L land, which is a part of schedule F land. Full stop. Moreover, it is submitted that this fact has been specifically mentioned in para 3 of the plaint,
Paragraph 13.
or para 13 of the plaint, yes. Full stop. It is also mentioned in para 13 of the plaint that as per partition, the predecessor of defendant number 1 and 2 got 4 kathas of land in Schedule E land, but at present, the defendant stroke respondent number 1 and 2 are occupying 5 katha, 15 lachas of land. And similarly, the defendant stroke respondent number 3, who also got 4 kathas of land in Schedule D, described by Schedule D, likh diya. Described under Schedule D, capital D, is occupying 5 kathas, 5 lachas of land, which clearly reveals that the defendant stroke respondent number 1, 2, and 3 are occupying land occupying surplus land, which is much more above their share of land. That it is further submitted that the pleadings clearly reveals that although there has been a typographical error in the prayer A, small a and small b, no? Of the plain, and in para 12 of the plain, comma, an amendment of the schedule of the land, and the inserting defendant number 3 will not change the nature and character of the suit. All right, and anything else to be included?
Yes, correction is concerned in paragraph, prayer portion B and C, Lord.
That I have said, prayer portion B and C, no,
And-
not A and B.
And paragraph,
A and B, no, B and C.
and,
A and B কৈছিলো না এই মাত্র small a small b, A, B and C হয়, B and C, yes.
and the statement made in paragraph 12.
Now paragraph 12 has mentioned.
Yes.
Anything else?
Yes.
Nothing, no?
No.
The petitioner has also relied on the decision of the, I'll give only one judgment each, huh?
Yes, Lord.
Which one? The best judgment on the relied on the decision of the Honorable Supreme Court
Right.
relating to this stage of trial, only one judgment. Which one?
Baldev Singh, Lord.
Baldev Singh. All right. And relating to mala fide, bona fide, and diligence, due diligence.
Right.
Which one? Bona fide, mala fide, and due
Baldev
diligence.
Singh, Lordship. Page
No.
9,
Baldev Singh is not relating to this is relating to the stage of trial.
Lordship. And then, Lordship, Ramesh Kumar Agarwal.
All right, only one. Yes. The petitioner has relied on the decision of the Honorable Supreme Court in Baldev Singh and others versus Manohar Singh and others, reported in 2006, within bracket 6 SCC 498, wherein it has been observed that মই blue tick মাৰি থৈ দিছো pencil দি এই judgment to page 9 of Baldev Singh judgment blue tick দিছো within inverted commas দি দিবা হা page 9, page 10, last part দেখো include কৰি দিবা in the reverting back to this case, reverting back to this case, the learned counsel for the respondents laid stress in his argument that the respondents will be highly prejudiced if amendment is allowed, because issues have already been framed. Issues have been framed, no?
That's it.
Issues have already been framed, and this case was proceeding for evidence. Moreover, full stop, moreover, the petitioner is not entitled, on the petitioner is liable to be dismissed as the petition was filed at a later, at the latest stage of dependency of the proceeding. Full stop. The learned counsel for a petitioner has submitted that the petitioner has, that the respondents have the option to file an additional written statement if the amendment, if the plaint is amended. In the wake of the foregoing discussions, it is held that the petitioners are yet to submit their evidence in chief on affidavit. Full stop. Trial has not yet commenced. I therefore find, full stop, I therefore find substance in the argument submitted by the learned counsel for the petitioner. The petitioner has also further relied on the decision of the Honorable Supreme Court in Ramesh Kumar Agarwal, next paragraph, versus Rajmala Exports Private Limited and others, reported in 2012 within bracket 2 SCC 5 2012 within bracket 5 SCC 337, wherein it has been held and observed that blue tick মাৰি থৈ দিয়া beginning to end যলৈকে মাৰি থৈ দিছো সেইখিনি লিখি দিলে ভৰাই দিলে হৈ যাব। এইটো ভৰাই দিবচোন। Reverting back to this case, comma, reverting back to this case, comma, it is held that it appears that the amendment may not cause prejudice to the other side as it appears that the amendment an amendment will not change the nature and character of the suit. So there appears to be no mala fide on the part of the petitioners. In the light of the decision of the Honorable Supreme Court in Baldev Singh's case Supra, and in the case of the in the light of the decision to Kati Jasun, a refusal of amendment may also lead to multiplicity of litigations. Full stop. In the light of the decision of the Honorable Supreme Court in Ramesh Kumar Agarwal's case, Supra, and Baldev Singh's case, the petition is allowed with cause.
Senior citizen, maybe.
Huh?
Senior citizen of 70 plus.
Hey, ekdom beginning of the petition is a senior citizen, age 75 years. Petition is allowed, okay. Petition is allowed. A prayer for amendment, petition is allowed. The prayer for amendment to amend the prayer to amend
Maybe corrected
paragraphs.
through bench assistant lordship.
What?
Instead of filing amended plan, that may be corrected through bench assistant lordship. It's only typographical error. It will.
Typographical. Should I hold it as typographical error? You file an amended petition. Allowed will लिख दिया. It's allowed in terms of the above observation petition stands. LCS.
The matter released to my lord.
Hmm.
Appointment of commission.
Hmm.
And my lord, notice was served, dossier service was complete, my lord.
Hmm.
They didn't appear, I think, my lord. So whether lord will take up the matter or wait for another day.
Pleadings are complete.
No, they didn't even appear, my lord.
Or did not appear.
There, in spite of notice being served.
Okay. Or despite notice being served.
Yes, sir. As per the order of the court,
I'll check the last order.
last order is, my lord, I think 24 of 8. And as per the order of the court, matter is restricted to court admission. I am ready, my lord, otherwise.
So it was Lisa's last day, last year.
Would you wait for one more day or
I
should-
think so. I think so.
But-
We ought to wait for one more day because they may not be aware that this matter has come up.
or should then fix the matter on 24th,
Hmm.
24th of March?
They have nobody's they are represented.
No, my lord.
Namu reflect one hai.
No.
The naam nahi mane party
After my lord, prolonged endeavor, my lord, notice was said to have
served.
been served. 3-4 times notice was, my lord. I took step, then dossier service. Even then, my lord, Lordship may fix the matter on 24th.
I think there's no point waiting. Because notices were served last year
My lord,
and then they are not represented.
my lord,
They have not appointed any advocate.
my lord.
So they are ignoring. I think
Madam.
no point waiting then.
Then Lordship will take up the matter.
Yes.
Yeah, I'll just. Well, by filing this petition, my lord, I have challenged 2 orders.
Hmm.
One is 1911.
don't know, huh?
My lord, one is 1911-2018, Annexure E, and next one is 11/4/2019. As your lordship knows, my lord, when there is a dispute, basic question involved in this case is whether court was absolutely right in rejecting my prayer for appointment of local commission. Initially, my lord, when we made an application, court said at this stage it is not appropriate because defendant has yet to adduce evidence. Therefore, we are keeping the matter pending. Then evidence was, my lord, reduced, and it appears that whatever question was said, my lord, that we raised, whether footland belongs to me or belongs to plaintiff, that could not have been ascertained on the basis of evidence. Then we made an application, my lord, with reference to earlier order. Now court is saying evidence is over. Therefore, no, it is absolutely not appropriate at this stage. Matter is at this stage of argument. Therefore, a commission may not be appointed. As your lordship knows, law is well settled. That matter saying that at any stage, my lord, commission may be appointed just to elucidate any dispute or any matter in dispute. And that is the whole object. And court didn't give any reason. Court simply said evidence is over. Court did not make any endeavor to ascertain whether student belongs to me or student belongs to defendant, plaintiff. Therefore, my lord, entire, my lord, matter is misconceived. Therefore, my lord, unless and until some amendment, commission is allowed to be appointed, and question is, my lord, ascertain, dispute is ascertained by the commission and submit a report before the court. Court may not be in a position to, my lord, adjudicate the matter effectively. And to that effect, a number of decisions there, I'm not going to trouble your lordship. Therefore, my lord, once we made an application, that should have been considered. Court didn't consider. Court said, my lord, I'm coming to the first order. At page 66.
Yes.
Short order, my lord. I'm just reading, my lord.
Yes.
Heard both sides on petition number so-and-so, under rule 20, order 26, rule 9 CPC, and today's order. By today's order, this petition would be disposed of. By said petition, the defendant prayed for issue of Amin commissioner. The defendant counter claimant contended that to ascertain the real disposition over the suit land, issue of Amin commission is necessary. The learned engaged counsel for the plaintiff, opposite party plaintiff, par contra, submitted that when in the plain and the written statement come counter claim, both the sides have set out their cases respectively, and they claim clearly there is no necessity to issue Amin commission. It appears on perusal of the entire case record that presently case is fixed for evidence on affidavit of the defendant counterclaimant. Amin commissioner is not an evidence collecting machinery for this court. Pausing for a moment, my lord, this is absolutely wrong conception. It is the absolute right of the party to adduce evidence by making a prayer for appointment of commission. Law is well settled, therefore that party is misconceived. At this stage, when the defendant counterclaimant is yet to adduce his evidence, it is not safe to decide at this stage whether the appointment of Amin commissioner to measure and ascertain the alleged disposition is necessary or not. This court therefore keep this open for consideration at appropriate stage. Therefore, I understand, my lord, question was not adjudicated, petition was not entertained because of reason that evidence is yet to be adduced by the defendant, number one. Number two, therefore, I keep the matter pending for consideration at appropriate stage. Then evidence was closed, my lord. Now, lordship, kindly come to next order. 11/4/2019 at page 69. May I read, my lord?
Yes, yes.
Both sides represented today has been posted for judgment by petition number so and supported by an affidavit, defendant counterclaimant number one prayed for passing appropriate orders contending that despite plaintiff filing written statement against the counterclaim, this court did not frame issue on counterclaim. The defendant counterclaim number one also contended that one petition bearing number so dated 12/9/2018, earlier petition matter. 12/9/28 is the earlier petition, which was kept pending, is still pending for disposal, which was filed with a pair for appointment of commissioner to measure the land of counterclaimant alleged to have been dispossessed by other defendants. Heard both sides, produced here under order 26/9. The object of local commission is to elucidate any matter which enables the court to properly and correctly understand and assess the evidence on record. It clarifies or explains any point which is left doubtful on the evidence on record. The suit is at the stage of judgment. As evidence has been closed long back, it cannot be said at this stage the factum of alleged disposition has been left doubtful in evidence and the evidence is unambiguous. Earlier he said evidence is yet to be adduced. Now evidence is over. The suit is at the stage of judgment as evidence has been closed long back. It cannot be said at this stage the factum of alleged disposition has been left doubtful in the evidence. The evidence is unambiguous. It is not the aim of order of 26 Rule 9 to assist the defendant number one to collect the evidence. Therefore, the prayer for local investigation cannot be entertained. This is the order first, my lord. Therefore, my lord, the question I raised, praying for appointment of Amin Commission is left out without any adjudication. Initially said no evidence, now says evidence is over, therefore it cannot be considered. Now, how court will decide who was dispossessed and what portion of the suit land was dispossessed by whom? They are saying that it is our land, we are saying it is our land in our counterclaim. And we said, my lord, some portion of the suit land was in their occupation. Now they filed a suit for recovery of possession, meaning thereby that some portion of the suit land was in our possession. Therefore, that part has to be asserted. And it is clear that defendant number one's petition for appointing commission of suit land is devoid of any tenable grounds as prayed for. Therefore, it is rejected.
TPG on dear.
I'm sorry, my lord. Today I thought my lordship will not take up the matter.
This is for admission only, but
Yes, yes.
as the other side was not there, I thought that
Then lordship may kindly admit the matter and wait for one other.
no,
As a lordship.
I'm not convinced about getting the matter admitted. You'll have to convince me further.
Pardon, my lord.
You'll have to convince me further.
Then Lordship kindly, then one more date may be given. Today I thought, my lord, they will appear.
This is the LCR we have, LCR.
LCR, my lord, I think.
LCR. One down.
LCR is in it.
Any stay order?
Hey, there is a stay order.
There's a stay order
Yes.
also. All right, then, I think giving you a date will be better.
My lord.
Maybe the other party may turn up, may
Yes.
not be. Learned Counsel Mr. A.K. Questor is present on behalf of the petitioner. Although the pleadings have stopped, although the pleadings are pleadings. Are complete, yet the respondents are not represented today. List the the Learned Counsel for the petitioner has prayed for adjournment. List the matter on
24th.
yes on 24th of this month.
And
this
interim
month.
order,
24/3.
my lord.
Yeah.
Interim order may be out to continue,
Interim order shall remain in force till then.
my lord. And on that day, my lord, if they don't turn up,
Hmm.
then Lordship will dispose the entire matter.
I'll dispose of the
Yes.
matter.
I'll prepare.
Item number 11, bail hearing.
May I please, Your Lordship?
Hmm.
Here in this case, my lord,
Mm.
I've been arrested on 19/1/2024, my lord.
Mm.
Almost 1 year, my lord.
Mm.
And scan copy of the trial court has been received, my lord, but I did not get time to go through, my lord.
Mm.
Learned PP, Mr. B. Sharma has gone through I think he has gone through the scan copy, my lord.
Mm.
Only 2 or 3 witness has been examined, my lord,
Mm.
out of 11, I think, my lord. So some time may be given, my lord, for the up-to-date scan copy, my lord.
Learned Counsel for the petitioner has prayed for adjournment. List the matter on. Meanwhile, data deposition day. Call for the scan copies of depositions of the witnesses recorded so far.
Ma'am, can it be on 28th, my lord?
Can be.
Obliged.
Item number 13,
Okay. Every matter be taken up just after compare my knowledge. Yes, yes.
item 14,
Here also, my lord, scan copy was called for, my lord.
Okay. We have received the scan copies.
Yes,
Scan copies.
I know I did not get time to go through the scan copy, my lord. Here also same, my lord.
Learned
And-
Counsel for the petitioner has
And only
prayed
one witness has been examined, my lord.
Yes, that's only one example. Learned Counsel for the petitioner has prayed for adjournment.
My lord.
List the matter on.
My lord.
Same date.
28th, not same date, my lord. Can it be some other date, my lord? Can be on 4th of April, my lord.
4th of April.
Obliged.
item number 15,
Wait, the Lordship. Lordship, in this case, Sasha has been submitted, Lordship.
Submitted, POSCO matter. POSCO matter. Shashi has been submitted.
Yes, now the status report is required, because Sarsit has been submitted on 31/05/2023, and thereafter no such report has been received.
In this case, Lordship, only summon has been issued, Lordship. Only summon. It's page 23, Lordship.
With that regard, topic may call for the status report. And other two reports in the later part.
We have the LCR, no?
Yes, LCR received only the two Sarsit topic. CD is there, but thereafter no such depositions.
Okay.
It's on report.
And respond, whatever respond number 2, this is a POSCO matter, so
Lordship, script has been received by the office.
Wasn't it shown by his name, Lordship?
Name has been sold. That means completed. Once PC not first. Appearing for respondent number 2.
yes, sir. কৈছে জানো নাই হোৱা নেকি?
Lordship,
I don't think so, huh?
His name is shown in the cause list.
Oh, cause list name দিছে নেকি? Okay,
Yes.
okay, চাব হৈছে তেতিয়াহ'লে। ইয়াতে কিন্তু there's nothing in the record, but
And Lordship, one more thing, there are two NDPS matters records are there, Lordship. That is,
NDPS records
yes, it's there. Okay.
in this case.
Yes,
Why?
I don't know, Lordship.
Earlier মানে wrongly district.
Oh, wrongly sent. এইটো অৰ্ডাৰ দিলে ভাল হ'ব নেকি? এইবোৰ কেলে এনেকুৱা পঠিয়াই থাকে জানো?
Follow it up, sir. Lordship. South Salman. And
This
present
NDPS case is relating to the same district.
one is Suksar PS, another is South Salman. South Salman. NDPS South Salman. NDPS to South Salman. No,
Learned Counsel, Mr.
M Mondol.
M. Mondal is present for the petitioner. Post of Miss S.S. Borua, Learned Edition PP Assam, Boradi is present. The name of the Learned Counsel for the respondent number 2 is reflected in the cause list. Post of the respondent number 2 is not present today. Or the respondent number 2 is not represented today. Post of. It is submitted that the status report is required as the LCR reveals that as the status report is required as the LCR reveals that category. Call for the status report of dependency of the special POSCO case number.
200.
Lordship, special POSCO case number 200 of the 2024.
Arising out of
Suksar PS case number 59 of the 2024.
from the respective court.
Yes.
List accordingly. No, list on
27 March.
27
And
March.
pending before the court of special judge, South Salmara, Manpach.
Item 16.
May I please allow? My lord, case diary was called for here.
You have the CD?
Yes, sir.
It's my lord, pre-arrest bail application, my lord. And in fact, this is the case, my lord, out of my lord fear, my lord, the victim girl has taken my name, my lord. Your lordship will kindly come to page 14, my lord. This is the FIR, my lord, against me, my lord. Page 14.
Yes, please read.
This is by one Muhammad Abul Hussein. She is said to be the father of the victim, my lord. And Amir Uddin, my lord, I am before your lordship. Respectful, humble president, on last month of March, the above named accused person for outing took my minor girl, Miss So-and-so, is it about 15 years, 6 months, to her related maternal aunt's house at So-and-so village under Lahorigarh police station. Later on that day at about 10 p.m., the said accused took my daughter with motorcycle from the aunt's house at So-and-so, saying to come home, stayed nearby the road of So-and-so village under the Lahorigarh police station, committed rape on my daughter, Miss Hasina Khatri. Now it is important, man. The accused threatened my daughter not to disclose about the said incident to anybody. Today, my daughter, on being told me about the incident, came to know this fact. In fact, this is by the my lord daughter, my lord. And this is my lord from her my lord statement that she is out of fear, my lord. She is my lord saying all this not to my lord
What do
mention the name.
you have in the CD? We call for the CD, no? What do you
Yes.
have in the CD?
Yes, Lord.
164 CRPC.
164 CRPC and 151 CRPC. He has categorically stated that the present petitioner has committed rape.
My lord, my lord, another fact is there, my lord. So this is by the my lord my victim girl to her my lord father, my lord. So after my lord 7,
Please read the vernacular part of the FIR.
yes, my lord. page 18, my lord. সন্মানপূৰ্বক এজাহাৰকাৰী বিনীত নিবেদন এই যে যোৱা মাৰ্চ মাহত, দিছ ইজ 3 months back, মানে উক্ত আছামীজন মোৰ ছোৱালী মিছ সোয়েনছো বয়স 15 বছৰ 6 মাহ লাহৰিঘাট থানাৰ অন্তৰ্গত নগাপাণ্ডা গাঁৱৰ সম্পৰ্কীয় মাহীয়েকৰ ঘৰত ফুৰাবলৈ লৈ যায়। পাছত সেইদিনে ৰাতি প্ৰায় 10
Where the accused detained behind the bar for 1 year 6 months, my lord. Next, my lord, 21, my lord. In 21, my lord, the accused completed 2 years, my lord, and 23, my lord, 1 year bill granted on 1 year 6 months, my lord. Para 23, my lord.
Okay. All right. Yes, yes.
My lord, in the record, my lord, there is just one question is there.
No, here in their, in this petition, he has annexed copies of depositions of witnesses. They have not implicated him. Four witnesses.
Four witnesses are witnesses.
Not a single witness has implicated him.
That is true.
Hmm.
My respectful submission, my lord, there is a possibility of acquitted by this.
Hmm?
There is a possibility of
Yes,
acquitted. my lord.
yes.
Kindly consider.
Hmm. Okay, then I'll pass an order later.
Lord,
You want some time? I'll pass an order later.
My lord.
I'll pass an order later. Or you want some time?
Sir, my lord, one thing is that, my lord, the total quantity, my lord, that is, my lord,
Hmm.
this, my lord, 3 something kg, this is opium, my lord.
that is different thing actually. Offense may be,
3.7 kgs of opium.
lordship, that is, the offense may be serious, but if the witness is not never stated any against me, my lord, then I am entitled to acquittal, my lord. Offense may be serious. That is correct, my lord. I admit, my lord. If my involvement is not there, my lord, I am entitled to whether it is serious or commercial quality. That is different thing.
You're relying on this the Guwahati High Court's order, or you're relying on the Supreme Court's order?
Supreme Court.
See, the Supreme Court's order, only 2 lines have been extracted.
Lord.
It's not clear, the Supreme Court's order, but this Guwahati High Court's order, he was
Clear.
behind bars
Oh.
for 2 years, 10 months.
My lord, my
You are behind bars for 1 year, 9 months.
9 my lord. My lord, express submission, my lord. 4 Caesar witness has been examined, my lord, and they have.
There only in this Guwahati High Court's order, I mean Justice Middle Court's order, only 1 witness was examined. And here 4 witnesses have been examined.
Your lord,
So how many witnesses are there?
9 witnesses.
9, my lord.
9 witnesses.
Total 9.
So your lord to kindly consider.
The IO is to be not examined yet, I think.
Those police personnel have not been examined,
Not
but
been-
this
Yes.
Caesar witness.
Caesar.
100, that section 100 of the CRPC, those witnesses have been examined. They always state in that manner. I'll pass an order in the evening.
Lord. Highly obliged.
Oh.
Item 17.
Yeah, with the lordship. My lord, this is 482
Hmm.
bail application. Lordship, may kindly see FIR page 7, man. Here, my lord, the present informant he is a person habitually files cases against some persons using his daughter as a weapon and squeezing money thereby. We have made category statement. Kindly see page para 5 of the
What about the respondent number 2's advocate?
Now, Lordship, I am a priest of a Namghar, and Namghar committee has given a certificate that this person is a very good, honest person since last 10 years. He is serving as the PS of that particular Namghar. Rohiyal Block Namghar Committee, so they have given the certificate. And my lord, this person who is the informant, he earlier also filed similar cases using the same girl of doing this ugly activities and thereby squeezed money. So I have given a categorical statement that Lordship may kindly see page 4, para 5. And absolutely there is nothing, my lord. Only said that I have tried. His statement is playing near the pond, page 7, Lordship may kindly see. My minor daughter of 7 years, daughter namely Juma Mujumdar, in his house, and when she was playing near the pond.
On 17. Do you have the CD or anything? CD? CD to be written, huh? Up to date. Then we will have to adjourn it for the beyond 17. CD is not up to date. Send me the CD call for the up to date CD list the matter on all 17. 26. No, CD won't go. CD will go back and come back. 26 March or all of comedy. Already 6 on 17. Then you retain the CD 17 then. But 17 go there. CD to be retained. CD to be retained till 17 March. Yes. After view vacation, as agreed by the learned counsel for both the parties, list the matter on after 6 weeks.
Item 22. Item number 22.
I saw the appellant's counsel in the morning, but now he is not there. After a week, yes. Learned counsel, Mr. A. Chaudhary. D. Chaudhary is present on behalf of respondent. There, he is there. Just a moment. Take it. Oh, this is his father, yes. হেৰু আছে নেকি মোহাম্মদৰ লগটো বেলেগকে আছে নেকি I think we have Yes, you can continue. This appeal substantial question of law has not been framed. Mm. There is no substantial question of law. Everything together. না এখন নহব এটা আছে 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 আছে। হুম, হুম। Please pass me your book. এখন নাই আর। Yes. That is the question number 2. এখন মোক ক'ৰবাত থাকিব লাগে ইয়াত বুজিছা। In your memo of appeal, you have given some suggestions of substantial questions of law in the memo of appeal. Page 6. And here, according to you, that question number 2 is sufficient. Yes. So we have 2 decrees now. We have 2 decrees before us, the trial court and the appellate court. Hmm. Yes. I think you'll have to put on the speaker. Yes.
If they file the suit seeking declaration,
Mm.
the suit starts at page 30. They are claiming
8:30,
declaration of right title, interest, confirmation of possession over Schedule A land, and recovery of first possession over Schedule B land as mentioned in the claim.
Hmm.
Schedule A land is 9 lecha and Schedule B land is 4 katha land.
Hmm.
So they pleaded in their claim that one Aburjan Nessa
Hmm.
was owner of a plot of land, page 32.
Hmm.
They have explained. One Aburjan Nessa, wife of late Kolom.
Page 30,
Page 30. Sorry, my lordship, page 40.
page 40, no?
40.
That's why I'm wondering. Page 40, yes.
Page 40, first paragraph.
Hmm.
1 bigha 3 katha 18 lesa was land belonged to Aburjan Nessa, wife of Kolom Sheikh.
Hmm.
And after her death, the plaintiff and one Noor Hussain
Hmm.
inherited those plot of land.
Hmm.
And in my written statement,
Hmm.
I have categorically stated
Hmm.
that there was a third son,
Hmm.
third son of the Aburjan Nessa, namely Amir Hussain.
Hmm.
At my written statement, I have categorically stated that there was a third son of Aburjan Nessa, namely Amir Hussain.
Which paragraph?
Page 69 of my written statement.
Namely, Amir said,
Amir Hussain.
Amir Hussain. Okay.
So he or his legal heir are not made party in the suit. So therefore, the suit was non-tender for necessary party.
Hmm.
On this suit, on this count, as well as on other counts, the suit has been dismissed.
Hmm.
That is, the trial court order is at issue number 3 is important.
This third son was not included.
Well, neither he nor his legal heirs are made party. The issue number 3, whether the plaintiff has right title interest over the suit land, that is important.
Hmm.
Not only on the basis of the non-tender of necessary party, but on the other parts, on the other grounds also, the suit was dismissed because he failed to prove that he inherited the Schedule A land or Schedule B land
Hmm.
from Aburjan Nessa. Issue number 3 at page 97 of the trial court. Trial court judgment starts at page 89. And issue number 3 is at page 97. You've got it.
I'm checking. Yes.
Trial court judgment starts at page 89,
Hmm.
and the important issue is at page 97.
Hmm.
Whether the plaintiff has right title interest over the suit land. May I read, Lordship?
Yes.
The plaintiff sought right title interest over Schedule A land measuring 9 lesa, covered by DAG number 200, Patta number 79 of Kalikazari Kissa Muza so and so so and so. The PW1, the plaintiff stated both in his plaint as well as evidence on affidavit that the suit land measuring 1 bigha 3 katha 18 lesa originally belonged to late Aburjan Nessa, wife of so and so. And while in possession, she died, leaving behind 2 sons, namely Abul Ali, who is the plaintiff, and late Noor Hussain, the predecessor of the defendant.
Hmm.
After death of Aburjan Nessa, the plaintiff and Noor Hussain inherited the suit land and dug a fishery in the middle portion of the land and amicably divided the land between them. As per settlement, each of them got 4 katha, 9 lessa of land as their share, including the fishery. Nur Hussain died, leaving behind principal defendants who inherited their father's share of land as described in Schedule
So
F.
this he is raising, this issue he is raising, I think.
Lordship,
Nur Hussein's legal heirs.
no, Lordship. Nur Hussain, I am representing the legal heirs of Nur Hussain. Amir Hussain was the another.
Okay.
That next page, Lordship, page 98.
Hmm.
During cross-examination, PW1 stated that they
Pasal
are
kaila hoga tum, pasal kaila hoga.
page 98, Lordship, I'm
Hmm.
reading. During cross-examination, PW1 stated that they are 3 brothers, namely he himself, Nur Hussain, and one Amir Hussain,
Hmm.
who died leaving 2 children. He also stated that he got land measuring 1 bigha, 3 katha, 5 lessa from his father, covered by tag number 501 and patta number 239. He denied the suggestion that he sold his share in that property to one Nur Muhammad.
Hmm.
Exhibit 1, the copy of Jamabandi of tag number 200, wherein the name of both plaintiff and defendant are mutated. Exhibit 2 is the Sitha copy of the same dag, which also discloses the name of Aburjan Nessa, the grandmother of both the parties. Lastly, Exhibit 3, some revenue paying receipt submitted by the plaintiff. According to the legal maxim, so and so, the burden of proving the existence of a fact lies on the person who claims or asserts its existence, or and not on the person who denies the same. As per Section 101 of the Indian Evidence Act, the burden of proof lies on the party who substantially asserts the affirmative of the issue and not upon the party who denies. As per the plaintiff, it is the plaintiff who is affirming the fact of their ownership over the scheduled land. Hence, the plaintiff who is under obligation to prove the same. It is admitted that both parties have inherited properties from their ancestor. However, none of the parties could clarify their own share of land. The plaintiff could not make it clear as to which tag and patta number belongs to him and which belongs to the defendant. The plaintiff has undoubtedly right title interest over the property of his father. However, the plaintiff has failed to prove that whether they have any right title interest in the suit land, that is dag number 200, patta number 79, situated at so and so, so and so.
Hmm.
Next page, Lordship. At this juncture, yet another view of this matter may be briefly discussed, which is with respect to the defense taken by the defendant. The plaintiff has sought eviction of the defendant from the suit land, but the defendant has taken a plea that they have been in long and continuous possession of the suit land since 20 years. Though they have not been able to lay any evidence to prove their title or possession over the same. It is also found that the plaintiff has concealed a very vital fact that he had 3 brothers, one of whom died, leaving behind his children. The children of late Amir Ali has not joined in the suit. In presence of Amir Ali, the whole story of the plaintiff will change. Therefore, it is found that the plaintiff failed to prove his right title interest over the suit land. Thus, this suit is decided in negative against the plaintiff. The court held that the plaintiff failed to prove his right title interest over the tag number 200 and patta number 79, that he inherited those property from his father.
Hmm.
So not only on the ground that he has not made Amir Ali a party in the suit, that was not the only ground for dismissal. Thereafter, he challenged this before the trial court, and in fact, in the trial court also, he did not explain that he is saying that Amir Hussain expired prior to expiry of Aburjan Nessa, his mother, but he has not disclosed the date of death. None of them, either of Amir Ali or of Aburjan Nessa, his mother. Being the first appellate court is a court of fact and law, he ought to have said before the court on which date Amir Hussain has expired or that Aburjan Nessa has expired.
Brother or mother?
Brother and
Date of
mother.
brother.
Hereafter, the trial court decided the same issue, Lordship, at page 25. Whether the plaintiff has right title interest over the scheduled land. In fact, this court, page 25, the issue starts. Trial court, the appellate court decision.
Page 25.
25. So in absence of the specific date, whether he expired prior to his mother or after death of his mother, that substantial law cannot is not a substantial question of law, in my humble submission. Issue number 3, Lordship, at page 25.
Because he has not stated the date.
He has not explained he has not given any explanation, either in the plain or in the appeal memo, He ought to have explained why he has not made why he has not made them party before at least before that first appellate court.
So page 25, which para? Issue
Page
number 2.
25 is the issue number 3 decided by the appellate court.
Yes.
Bottom, Lordship.
Yes, yes.
Issue number 3, whether the plaintiff has right title interest over the suit land. The learned trial court held that admittedly both the parties have inherited land from their predecessor, but none could clarify their share. That the plaintiff failed to make it clear as to which dag and patta belongs to him and which belongs to the defendant. The trial court held that the plaintiff failed to prove whether he has right title interest over the dag number 200, patta number 79. Be that as it may, in the instant appeal, the appellant plaintiff contended that the trial court failed to appreciate evidence on record properly. The trial court erred in holding that plaintiff does not have right title interest over the suit land. The plaintiff in the suit contended that he and Nur Hussain jointly inherited 1 bigha 3 katha 18 lesa of land, which was amicably partitioned between them. Thus, the plaintiff and the predecessor of the present defendants got 1/2 each, that is 4 katha 9 lesa of land out of total land measuring 1 bigha 3 katha 9 lesa. However, the defendants have denied the amicable partition of the 1 bigha 3 katha 9 lesa. The plaintiff in the suit has not laid any cogent evidence to prove the fact that 1 bigha 3 katha 9 lesa of land was amicably partitioned by him and his brother Nur Hussain, the predecessor of the defendant. The plaintiff has failed to state the exact date or year when the amicable partition of the land measuring 1 bigha 3 katha 9 lesa took place between him and his brother. Further, the plaintiff has not submitted any sort of deed of partition in the suit at the hand to prove the fact that the land measuring 1 bigha 3 katha 9 lesa was partitioned and that he and Nur took 1/2 each, that is 4 katha 9 lesa each. The plaintiff in the suit has produced 3 documents to prove his right title interest over 4 katha 9 lesa of land covered by dag number 200 of patta number 79. The plaintiff as PW1 has exhibited 1 certified copy of the Jamabandi of dag number 200 of patta number 79 and marked the same as exhibit 1. I have perused the exhibit 1 and found that dag number 200 and patta number 79 contains 7 bigha 17 lesa of land, and there are several pattadars including the plaintiff and defendant. The exhibit 1 does not specifically show that 4 katha 9 lesa schedule C out of 7 bigha 17 lesa are in exclusive possession of the plaintiff. Thus, the exhibit 1 do not prove the fact that the plaintiff has exclusive right title interest over the suit land measuring 4 katha 9 lesa. The Jamabandi which he produced before the court shows 7 bigha 17 lesa of land in total, but that does not specifically show that he owns out of that land 4 katha 9 lesa. Next, Lordship, which is described in the schedule. In fact, Exhibit 1 shows both the plaintiff and defendant joint owner of the land in the Jamabandi of tag number so and so. Moreover, there is no cogent evidence to show that the plaintiff and Nur Hussain mutually partitioned the land measuring 1 bigha 3 kotha 18 lesa. There is no documented evidence to show that plaintiff share consists of 4 kotha 9 lesa of land as described in the Schedule C of the plain. Next paragraph. Further, the Exhibit 2, which is a certified copy of Sitha of Patta number 79, shows Aburjan Nessa possessed the suit land, but the same do not show the plaintiff inherited the land. Whereas Exhibit 3.1 to 3.5 are the revenue paying receipt, which is no way prove the right title interest of a person over the plot of land. Furthermore, the learned trial court held that the plaintiff is not entitled to any relief as the plaintiff has not come with clean hand. The plaintiff had concealed the fact that there is more than one legal heir of Aburjan Nessa, that is Amir Hussain. It is held by the learned trial court that Aburjan Nessa had 3 sons, namely Abdul Hussain, the plaintiff, Nur Hussain, the predecessor of the defendants, and Amir Hussain. Amir Hussain is no more, but his children have not been made party in the suit. I perused the cross-examination of the plaintiff and found that plaintiff has admitted the fact that he has one more brother, namely Amir Hussain, who is no more now. The plaintiff has also admitted in his cross-examination that children of Amir Hussain are alive. However, the case record shows that sons and daughters of Amir Hussain have not been made party in the suit. In the appeal, the plaintiff contended that Amir Hussain predeceased their mother, Aburjan Nessa. Therefore, as per Muslim personal law, the children of Amir Hussain are not entitled to inherit any property left by Aburjan Nessa. It is no doubt that the law that children of a Muslim who dies prior to the death of his father or mother are not entitled to inherit any property left by their said mother or father. However, I have not found any plea or statement in the plaint or in the testimony of the plaintiff to show that Amir Hussain died prior to the death of his Aburjan Nessa. It is not stated by the plaintiff as to when Aburjan Nessa and Amir Hussain died. The plaintiff has failed to give the date of Aburjan Nessa and Amir Hussain. In fact, Lordship, the Honorable Appellate Court has already decided this issue, and on this issue, he cannot satisfy the court. Therefore, the suit as well as the appeal has been dismissed. Therefore, it cannot be held that Amir Hussain predeceased his mother, Aburjan Nessa. Thus situated, it cannot be held that children of Amir Hussain are not entitled to inherit any property left behind by Aburjan Nessa. Hence, the learned trial court is right and correct in holding that plaintiff is not entitled to any relief as children of Amir Hussain have not been made party in the suit and the plaintiff has not come with clean hand and thus he is not entitled to duty. In the light of the above discussions of the evidence, facts and application of law, I am of the considered view that so and so. So it was decided against the appellant plaintiff. So this issue, whether the Amir Hussain's legal heir are necessary or not, so whether he predeceased his mother or not, this issues has already been decided by the first appellate court as well as trial court. So in fact, in this second appeal also, he has not given the date of the death of his mother and brother. So in my humble submission, the substantial questions of law which has been proposed are not substantial questions of law for admission of this matter. And I would like to rely on two judgments, Lordship.
Yes. So this, according to the plaintiff, the petitioner, the appellant, as he has already predeceased, so he was not named as arrayed as a defendant.
They are saying now, that he has not been, Amir Hussain has not been made party in the suit or in the appeal because he predeceased his mother. But whether those facts are proved by way of evidence or whether those facts are pleaded before the court, That is to be seen. First of all, Lordship, the plaintiff has to prove his own case.
Yes, yes.
That is 2019 6 SCC 82. Jagdish Prasad Patel versus Shivnath and others.
Hmm.
And that is paragraph, Lordship. Paragraph 44. 2019 6 SCC
Hmm.
82.
Paragraph 44, yes.
42. Sorry, 44. Lord.
44, yes.
44. In a suit for declaration of title and possession, the respondent plaintiff could succeed only on the strength of their own title and not the witness of the case of the appellant. The burden is always on the respondent plaintiff to establish their right, establish their title in the suit properties to show that they are entitled for a decree for declaration. The respondent plaintiffs have neither produced the title documents, that is patta list, which the respondent plaintiff are relying, nor proved their right by adducing any other evidence. It is as noted above, the revenue entries relied on by them also held not to be genuine. In any event, revenue entries for few khataunis are not proof of title but are mere statement for revenue purpose, and they cannot confer any right or title on the parties relying on them for proving their title. But paragraph 45, observing that in a suit for declaration of title, the respondent plaintiffs are to succeed only on the strength of their own title, irrespective of whether the appellant defendants have proved their case or not. In Union of India versus Basavi Cooperative Housing Society, it was held as under. It is straight law that in a suit for declaration of title, the burden always lies on the plaintiff to make out and establish a clear case for granting such declaration, and the weakness, if any, the case set by the defendant would not be a ground to grant relief to the plaintiff. Plaintiff have measurably failed in this suit that to show that whether they are entitled for declaration of right title interest over the suit land. They only relied upon the Exhibit 1 Jamabandi, which only shows that there are seven bigha and odd land, but the plaintiff could not show how much land belonged to him or how much land was under possession of Aburjan Nessa, his mother. So, and by virtue of the revenue entries only, he cannot ask for declaration of right title interest. And the second judgment, Lordship is already aware, Lordship. This is a 2019 6 SCC 409. Regarding second appeal, Lord. Paragraph is at 7.2. As observed by this court in Kondiba Dagu versus Savitri Bai, in the second appeal under section 100, the High Court cannot substitute its own opinion for that of the first appellate court, unless it finds the conclusion drawn by the lower courts are erroneous, being contrary to the mandatory provisions of applicable law. In this case, not applicable. Contrary to the law pronounced by the apex court, and based on inadmissible evidence or no evidence. This further observed by this court in the aforesaid decision that if the first appellate court has exercised its discretion in a judicial manner, its decision cannot be recorded as suffering from an error either of law or of procedure requiring interfering in the second appeal. It is further observed that the trial court could have decided differently is not a question of law justifying the interference in a second appeal. After the paragraph number 8.
Paragraph 8, yes.
Having gone through the findings recorded by the trial court as well as first appellate court, it appears that both trial court and first appellate court gave cogent reason on application of on appreciation of evidence on record, more particularly the cell deed number so and so. In this case, it was cell deed. and subsequent sale deed number so and so, and thereafter held that plaintiff is not entitled to a declaration that he has become the owner, while interfering with the judgment and decree passed by both the courts below. It appears that High Court has given reappreciated the entire evidence on record, which in exercise of power under Section 100 is not permissible. Under the circumstances, High Court has committed grave mistakes, so and so, so and so. So already that substantial questions of law, which has proposed by the my learned friend, has already been discussed, and now if those substantial questions of if the proposed questions are already again framed, Lordship will reappreciate the evidence already decided, already discussed or appreciated by the first appellate court and the trial court. So in my humble submission, this matter may be dismissed by the without it.
Here's a point.
Yeah, on the top why
No, not full-fledged argument. This is relating to substantial question of law.
regarding the, supposing I have not stated in my claim that another brother was there here. All right, but in written statement it has come. While it has come, your lordship would be pleased to see the issue. Yes, yes, I think. Sorry, madam, 90. Yes, 90. My humble submission to your lordship. After written statement. While issue is framed, my lord, after written statement is filed and plaintiff file is framed and thereafter.
Page 97.
After going through the
Yes.
claim,
Mm.
pleadings of the party, issues are framed.
Mm.
So they say that there was another brother, Amir Hussain, that was not valid, he died. Now, when that question comes back,
Mm.
immediately there should be a issue
Mm.
whether Amir Hussain was entitled. Amir Hussain, son of Amir Hussain is entitled. No issue has been framed. Your lordship will see the issue. Page 95. Whether there is any cause of action of the suit, general issue, whether suit is maintainable in its present form, whether the plaintiff has right, title and interest over the suit, whether plaintiff is entitled.
See, it was decided in issue number 3 that the suit is bad for non-gender of necessary parties.
Non-gender or necessary party, that is my question before your lordship. That when somebody died before his father, then son is not entitled, how that dead son or his issues will be necessary? That is the question is to be decided. Wherefore has gone wrong. I humbly submit before your lordship. Wherefore has gone wrong. Because my lord, a person, he did not have any right, he died, and his sons are not entitled to the property. Whether they will be the necessary party? That is a pertinent question.
It was decided, no?
Already decided, and in fact, he
No, my
failed
lord.
to give any date.
And my friend are good, my lord. I did not
Lordship.
get any.
Sorry, sir.
Please.
Sorry.
No. Let me submit and you will reply. Sit comfortably. My humble submission before your lordship. First thing is to be decided first. Whether son of Amir Hussain, predeceased son of the Patrada, is necessary party in that. No. Because Mohammedan law said that they are in the outside. They are outside from claiming the property.
when they are ousted from the property. Somebody is to be made party, who are necessary. Those who have any interest under law, any interest
You're
under.
bringing them in a very twisted manner,
My lord,
going round and round and round and bringing them in.
my humble, that is fine. Appeal may be admitted, let the record stand. There will be full-fledged hearing, because it is a legal question I raised before your lordship. Why that? My learned friend submitted before your lordship that issue has been answered.
Yes,
The issue
Has been answered. Yes.
That not necessary party.
not maintainable because they are not necessary, they are necessary
not-
parties.
They are not,
They are necessary parties.
I humble submission, they are not necessary party because they do not have any claim over the property. Claim over the property. Shoot property, they do not have any right on the shoot property. How they can be necessary? They cannot. They cannot. And that particular issue, that grandson, whose father predeceased the father, is not entitled to property. Are they necessary? They are not. So
Yeah, I think
that is the
he has a
question, my
point.
lord. That is the question. Whether they are necessary party. When somebody, supposing land belong to A, how B will be necessary party?
But see, actually, maybe you have a point, but see, why didn't you mention when this person died? How did he predecease his
That
mother?
That we tried before the court below, that he do not have any right. That is why he was not made. And
Okay, he was
we
not,
have
but
said anything.
you have not mentioned
That
how,
point,
on
that is-
which date
that
he
is
died.
Another aspect of the matter, that I conceal something. But your lordship, when I am raising a strong point of law, supposing either or way I did not disclose, no interest is hampered. Supposing I disclose. If I disclose that I have another brother, he died. He died before my father. Then whether that will change the character of the suit, that will give any benefit to them? No. So that concealment, my lord, maybe it is not proper concealment. But whether is the necessity? If I say that one brother has died, whether he will give any right to the sons of the this is the person? No. If that is not the case, then by not stating that my one brother died, but who will be bad for deciding this legal question?
I think he has a point. One question can be framed, I
My
think.
lord,
Only one question.
only one point, my lord, that if that is decided.
Only one question can be
2
framed.
minutes. 2 minutes.
My lord, if that point is decided by your lordship, everything will be in the line. Because it would below my lord, stand on, because they are holding that they are necessary part. So they are not made part. That is why I'm not.
See, there's a question of law.
Yes.
No facts will be brought in.
Okay, 2 minutes. The suit as well as the appeal was dismissed on twofold. First, he failed to prove his right title interest over the scheduled land. And second, he had one brother. So,
No.
Lordship,
He's the heir of his mother.
Lordship, yes, Lordship.
Maybe not over the suit land,
Lordship,
but there's a
Aburzan-
Jamabandi
Aburzan-
executed road containing 7 bighas of land.
Aburzan Nessa had 3 sons. So, in the suit as well as in the appeal, it has been said that he has not made one of the son a party respondent. One thing. And another thing is that he failed to prove his right title interest. So, even if assuming that Aburzan Nessa is a necessary party or not necessary party, so whether his suit can succeed. Because in absence of proof of any right title interest over the suit land, whether that Amir Hussain has been made party or not, that is irrelevant. So whether by virtue if Lordship decides that Amir Hussain is not necessary party or he is a necessary party, on that only he cannot succeed the suit. His suit. He has to show before this honorable court that he has right title interest over the land. And the trial court and the first appellate court has rightly discussed those things. The trial court has not only
Yes, yes.
dismissed the suit
He has
only
not
on the basis of necessary party. The trial court has explained that he has
Which
failed
part
to-
of the share he has?
yes, Lordship, that it has been categorically mentioned that the plaintiff has failed to state the exact date or year when the amicable partition of the land measuring 1 bigha 3 katha 9
Which
lessa
page?
took
Which
place.
page?
Page 26.
Yes.
Page 26, bottom 1, 2, 3, 4, 5. The plaintiff has failed to state the exact date or year when the amicable partition of the land measuring 1 bigha 3 katha 9 lessa took place between him and his brother. Further, the plaintiff has not submitted any sort of deed of partition in the suit land to prove the fact that land measuring 1 bigha 3 katha 9 lessa was partitioned and he and Noor took one half each, 4 katha 9 lessa. The plaintiff produced 3 documents to prove his right title interest over 4 katha 9 lessa of land covered by DAG number 200, patta number 79. The plaintiff as PW1 has exhibited certified copy of the Jamamandi of DAG number so and so and marked the same as Exhibit 1. I perused the Exhibit 1 and found that DAG number 200, patta number 79 contains 7 bigha 17 lessa of land. And there are several pattadars, including the plaintiff and defendant. The Exhibit 1 does not specifically show that 4 katha 9 lessa, that is Schedule C land, out of 7 bigha of land are in exclusive possession of the plaintiff. Exhibit 1 does not prove the fact that the plaintiff has exclusive right title interest over the suit land measuring 4 katha 9 lessa, which is described in the Schedule C of the plaintiff. Lordship, even if assuming that this court declares that Amir Hussain was not a necessary party, or on that count the suit cannot be dismissed, then what will happen to these findings, Lordship? Regarding right title interest, this trial court and appellate court has already decided that he is not a he has no right title interest. Even if assuming that on the trial court and appellate court does not went to the issue of non-gender of necessary party. On this count, the suit has been dismissed. The suit has been dismissed on twofold. So that is my humble submission.
Strongly argue that if first point is taken by your lordship. So my humble submission is your lordship. The issue substantial fiction on law is very important. We are before the Honorable High Court. What the Honorable High Court will decide, that is the law on subordinate. No. That is the question is to be decided. Whether in the long run, I will win the case or not.
Yeah, yes,
That is
yes,
not
you are right,
fair.
yes, right.
But my
But he is apprehending that it will open floodgates, that is why.
submission is what my landed friend taken decision. Please before your lordship. The Honorable Supreme Court said that before coming to the decision referred by my landed friend, before coming to the decision, the Honorable High Court, what to have done for the entire evidence. Here in this case, when my defendants, my lord, did not use any evidence. Yes, it's said by the court below, my lord, for appeal, that it is not the burden of the defendant to prove the evidence, and I cannot get benefit from the defendant. But my question is this one. What is the problem with them? I will prove my case, no problem. But what is the
Yes, I
problem
think
with
this
them, my
question
lord?
of law can be framed, I think.
Please, my lord,
It won't open any Pandora's box, only one question of law
my lord. That will
can be
my lord,
framed.
your lordship, that will be decided and that will be the law. That will be the law.
No, I'll just admit it.
And
I'll frame the substantial one question of law, I'll admit
only
it.
one. Yes.
এইটো লম্বা হ'ব ডিক্টেশ্যনটো কৰিবা ঠিক আছে কৰি লোৱা কিবা প্ৰব্লেম হ'লে সুধিবা আই উইল বি ডিটেক্টিং ইট উইল টেক মি সাম টাইম and then I think I'll be able to take up only 1 or 2 case.
Only one thing,
Uh,
I have one idea. When I move this case first, but what if take that let the notice issue, then we decide on the idea. Well, at this point of IA, regarding this point of, they are in possession of the land, no problem. Only by prayer before your lordship, they should not alienate the property status to anywhere. They are on the land.
no. We'll admit it, we'll take it up later.
Yes.
They are already in possession, so why this hurry emergency about the
Only
eye?
only thing is this. They are in possession. I will not get. By admitting this subject, my lord, I will not get the land.
Yes, yes.
They will remain in.
Status quo will be
But
maintained.
only thing is, my lord, they should not have the pressure of the land.
No, but you see,
Or they may
no.
tag the land or.
Now, I cannot, without framing substantial question of law, I cannot pass an order for status quo. Without framing, first I'll have to frame the substantial question of law.
Regarding
Then
this
we'll take
matter-
up the IL later.
Then-
Yes, now it's already 3. I'm just addressing to the court. Already 3. I won't be able to take up any more, I think. Maybe I'll dictate a few, I'll pass an order because they have submitted a few judgments also. I'll pass an order, it'll take me another 15 minutes. So maybe another 15-30 minutes.
In that case, my lord, but I will remain.
Yes, he will remain. Your junior will
Copy
remain.
of the IL. We have not received a copy of that.
See, you have to give a copy also.
Obliged.
But learned counsel, Mr. M.S. for the appellant. Item 22, no?
22.
Sit down. You can go. Your junior will be here. You can go.
No.
But I can.
Yes. No, you can go.
Well,
I'm asking him to sit down. He's been standing, so. Where is the plate? Page?
Plane starts at page 38.
M.S. लिख लो. The appellant, Mohammad Abdul Ali, who was the plaintiff, who is also the plaintiff, Who was also a plaintiff nalage? Atili. Mohammad Abdul Ali has filed his appeal as is agreed by the judgment and order dated 6/3/2024, passed by the learned civil judge within bracket senior division bracket close Morigaon, Assam, in title appeal number 8 of 2023. First, the aforementioned title appeal 8 of 2022 was dismissed. Upholding the judgment and order dated 11/8/2023, passed by the learned civil judge junior division within bracket junior division bracket close number 2, dismissing the title suit number 9 of 2022 preferred by the appellant stroke plaintiff Mohammad Abdul Ali. Heard Mr. Your name?
D. Chaudhary.
D. Chaudhary, no? Heard Mr. D. Chaudhary, learned counsel for the respondents number 1 to 9. Who are the legal heirs of Nur Hussain, of late Nur Hussain, legal heirs of late Nur Hussain. It is, I have considered the submissions at the bar. So it is submitted by the learned counsel for the respondents that there is no substantial question of law to decide this appeal, and this appeal is to be dismissed. While bringing up the title suit, the appellant had concealed that Abujan Nessa, no? Late Abujan Nessa was survived by 3 sons. Full stop. The appellant has mentioned that the 3 sons, full stop, the appellant has not arraigned, arraigned, arraigned Amir Hussain as a party to the suit. Late Amir Hussain has not arrayed. Late Amir Hussain as a party to the suit. The trial court as well as the appellate court through their concurrent judgments have correctly held that the appellant has no that the suit is bad for non-gender necessary parties. Full stop. It has also been correctly held by the trial court as well as by the appellate court that as the appellant has not described his share of the property, comma, the partition his share of the property here has not described his share of the property specifically in the plaint, comma, it could not be ascertained. The appellant has failed. The appellant has failed to ascertain to prove his case, to prove his case. The learned counsel for the respondent has relied on the decision of the Honorable Supreme Court in Jagadish Prasad Patel, within bracket dead, bracket close, through legal representatives and another, versus Shivnath and others, reported in 2019, within bracket 2019, bracket close, 6 SCC 82, wherein it has been observed that there are 44. एक मिनट, हाँ. Para 45, দুইটা, para 44, 45. The learned counsel for the appellant as well as the learned counsel for the respondent has also relied on the decision of the Honorable Supreme Court in Thusali Dhada and another versus Narayan Nappa and others, reported in 2000, within bracket 2019 bracket close, 6 SCC 409, wherein it has been observed that is submitted by the learned counsel for the appellant that at this juncture, the substantial question of law relating to the that the substantial question of law can be framed, and this court may not get into the details of the evidence relating to the document marked as Exhibit 1, that is the Jamabandi, full stop. If the issues framed by the learned trial court is taken into consideration, comma, it is apparent that no issue was framed if this suit is maintainable for non-joinder of necessary parties, and thereby and thereafter the trial court proceeded to dismiss the suit. Title suit number 8 of 2020 কিবা আছিল নেকি 8 of 2020 no, title suit 8 of 2023 number. Huh? Oh, 9 of 22. Oh, for non-gender necessary parties. It is submitted that when Abujan Nessa's son Amir Hussein has predeceased her, comma, it was not the legal heirs of Amir Hussein were not necessary parties to the suit, and this issue can be framed as a substantial question of law. After considering the submissions of the bar with circumspection, it appears that the substantial question of law in this case is whether the heirs of predeceased son of a Mohammedan deceased Pattada is a necessary party in the suit in hand, full stop. Thereby, thereby, full stop with it. The appeal is admitted. Then in the IA will issue notice.
The notice is already been issued with the IA.
Notice has been issued.
We have not received a copy.
এনেকে লিখি দিবা হেৰি আইটো লিখি দিবা both the parties are present. The the opposite party is to furnish copy of the IA to the applicant. After 4 weeks, you have to you are the yes, you have applied. The appellant is to provide copies of the application IA to the respondent. So to do it, release this matter after 4 weeks. We have admitted, we have called for the LCR also.
I think it has been received.
No, there is a submission for stay. We'll take it up on the next day. So we have framed only one substantial question of law. Can you DD person one check with our legal video? No, he stays. We can admit it for hearing, but it will not come up for hearing. It will come up for orders only, because we have issued notice and you have to submit for against the IA also.
Not.
Objection maybe. The orders are rahibo. Appeal is admitted for hearing will lead to it orders are rahibo.
Item 24. Item 24.
The parties are not represented today. The parties were also not represented on the previous date. Does this matter after 4 weeks?
Item 25.
Parties are not represented today. Leaves this matter after Bihu holidays.
Item 26.
Please put on the speaker.
Lordship, please, your Lordship, by order dated 14/12/2023, it was directed that track report may be filed. Accordingly, track report in regard to the service to the respondents is supposed to be filed. In regard to the affidavit was filed, wherein respondent number 1 and respondent number 3 is reflected that notice has been served. However, respondent number 2, 4, 5, and 6, the notice is returned to the sender, that is to the Honorable Guwahati High Court, with the respective event endorsement as item returned, addressee left without instructions. Lordship, at this juncture, fresh notice may be issued in regard to 2, 4, 5, and 6, who was respondents hearing. And Lordship, 14/12/2023, in that particular order, interim also is there in this particular matter, wherein interim order passed earlier stands extended till further orders. That was there.
Interim order?
Yes, and interim order is also there.
Item number? There's no interim.
20.
20?
26. Lordship, order dated 14/12/2023.
40?
12/2023. However, the same was
It
not.
has not continued.
That is, Lordship, however, the hearing, it was written interim order passed earlier stands extended till further orders. That was not reflected in subsequent 2 orders.
Okay. You are petitioner in person?
No. Petitioner, I'm at
What is your name?
TR Sen, Lordship.
P? TR Sen, okay. Learned Counsel, Mr. TR Sen is present for the petitioner.
My lord, I appear for respondent 7, pro forma respondent.
Learned Counsel, Mr. I. Bothago, I. Bothago is present for the respondent number 7. 7. Then what about 1 to 6? You have said something?
Yes, 1 and 3 notice has been served. However, I have not.
There is a track consignment report.
Yes.
Where is it?
But that has been annexed as an annexure at this point.
21 to 25. Needed ID card. So notice issued to respondent number 1 is awaited.
Lordship, 1 and 3, that is 1 and 3. That
No, this order dated liquidate. Order dated 21/2/2025 reflects that notice issued to respondent number 1 is awaited. And what about 2, 3, 4, and 5?
Lordship, 2, 4, 5, and 6, that has not been that has been returned. That is not been served. Respondent number 3 has been served. That is, I'm in view of the affidavit which has been filed. The tracking consignment reports are annexure 14, 15, 16, 17. That's our.
I don't notice office note dated 21/2/2025 with a Kati. Office note dated 10/2/2025 indicates that an affidavit is filed on behalf of the petitioners regarding steps taken by registered post on respondent number 1 to 6 and submission of postal track reports has been received by the section flag A to side আছে flag A Pino আছে এটো Oh, we do affidavit. Who the affidavit is submitted that notice issue the track consignment report reveals that notice has been delivered in the address of respondent number 1, comma 3, post of the affidavit. It is also submitted through the affidavit that the notice issued to respondent number 2, 4, five and 6 have been returned. Notices issued to 2, 4, 5, and 6 have been returned to the addressee as the respondents have left the address without instructions. You want to take fresh steps?
Not fresh steps can be taken.
Petitioner may take fresh steps to issue notices to the respondents. Returnable within 4 weeks?
4 weeks.
4 weeks. List accordingly.
Lordship in regard to the interim which was
Okay, interim order shall remain in force till the next date of listing.
Item 27.
TP of it.
May please order.
Yes,
I'm for a petitioner and this, we took steps upon the respondent. Now learned counsel for the respondent have taken please ready to accept, has already accepted all the, for all the respondents. So this is, the service is, if it is complete, my lord, let this matter come up for admission, my lord.
You are present for all the respondents.
Yes, Lord, respondent number 1 to 4 and Lordship 6 to 8. Lordship.
1 to 4 and what about 5?
Lordship 5 has Lordship died.
Okay, passed away. Substituted.
Yes.
Then who will represent the legal heirs of respondent number 5?
And feels that Lordship, they have not communicated.
Same family.
Yes, yes, same family.
You won't represent him.
Yes.
You'll represent him.
No,
5 you won't.
I'm not representing Lordship. I'm representing only 1
Then
to 4 and
you'll have
6.
to serve notice to the legal representatives.
My lord, only on that is,
Where's the
Well,
IA substituting the legal heirs?
my lord, only one. It is
Where is the
5.
IA substituting the legal heirs?
Yes, yes. 1484.
148.
2020. 1484. And upon the respondent number at page 3, my lord, 5E, we took steps on my lord 18/9/2024. This is the filing slip, my lord.
IA 1484.
Yes. But regarding substitution, I have no objection.
This is not matter relating to substitution. 1484.
Yes, my lord, at page
Oh, yes, yes.
Yes.
Yes, yes.
page 3,
Mm.
5E mainly particular.
You have no objection, then
Yes.
it will be substituted then.
Yes.
Our learned counsel, Mr.
R. Goswami.
R. Goswami for the 1484 लिखिएगा, हाँ 1484 for the applicant, and learned counsel Mr.
M. Boro.
M. Boroloskot.
M. Boro.
M. Boro for the respondents number 1 to 8. Respondents number 1 to 8.
2, 3, 4, 6, 7.
1, 2, 3, 4, 6, 7, and 8. This application is filed by the applicant for substitution of the legal heirs of respondent number 5,
5.
who has passed away on respondent number 5 to Abu Tahir,
Right.
who has passed away on 13/5/2016.
Yes.
Was there any delay in filing this?
No, my lord. No. And they are not, my lord, objective.
I think there has been a delay in filing this petition.
With you. With the thunder. Only with the light.
When did he pass away?
He expired on paragraph 10, my lord, page 7.
Okay, okay. Full stop. Therefore, as per order dated 2/4/2018, passed in CRP number
IO.
IO, passed in CRP within bracket IO bracket close number 56/2018, the petitioner was directed to take steps for substitution of the legal heirs of the respondent number 4 by this court. It is submitted that there was a typographical error of the names of the legal heirs of the respondent number 5, Abu Tahir, in the IA within bracket C bracket close number 2516/2018 in CRP IO within bracket I stroke O bracket close number 56/2018. Full stop. An order was passed for correction of the typographical errors. Later, or later, alike, it is also submitted that one more name is to be added in the
Revision.
one more name is to be added in the revision petition. This is a revision petition or appeal?
Revision.
Okay.
Yes.
one more name had to be added in the revision petition as respondent number 6. And this court had allowed the and this court has allowed no, as he is also a respondent in the IA, and he is also a respondent in IAC number 2516 of 2018. So you have no objection for substitution of the legal years mentioned in the petition.
Yes.
The learned counsel for the respondent stroke opposite parties has no objection if the legal heirs named in the petition are substituted as respondents. Considering the submissions, prayer for substitution of the legal heir of respondent number 5, Abu Tahir is allowed. In terms of the above observation, application stands disposed of. So this is so anything else left out?
No, my lord, next step will be for admission. The CRP, IO,
There's one more I.
one four eight eight. That is, my lord, regarding the respondent number 5. Then subsequently 5, he was added, my lord.
So this is the last application which I have disposed of at the
Yes.
first.
Yes. Since, my lord, all the respondents he has, my lord, taken, my lord, admitted that he has no objection, my lord, and he has already appeared for others, my lord. Then we, my lord,
Yeah, I'll dispose it at the dispose on the iOS.
yes.
এইটো লিখি দিয়া same parties লিখি দিবা respondent number 1 এইটো IA number 1488 আৰু 2022 হেৰি দুজন এডভোকেট যাৰ কাৰণে এপিয়াৰ কৰিছে এনেকে লিখি দিবা তাৰপিছতে প্ৰেয়াৰ পৰ্চনটো
To allow the respondent number 5.
এইটো পেৰাগ্ৰাফ 4 আছে প্ৰেয়াৰ পৰ্চন
হয়।
পেৰাগ্ৰাফ 4 আৰু 5 এইকেইটা ভৰাই পেলাই এলাউ কৰি দিলে হৈছে
In the, my lord, main CRT IO 56 of 2018, this matter may come up for admission hearing, my lord.
no, there's little bit of here's a condonation of delay. This is a condonation of delay petition. Paragraph 3 to 3, 4, and 5. This also I have disposed of. You have no objection? Para 11 ভৰাই দিবা। Both parties লিখিলে para 11 টো ভৰাই দিবা। Nine, 10, 11. Para 9, 10, 11. Any objection in this petition 2516?
No.
2517. Para 2, 3. 4, 5, 6. 2, 3, 4, 5, 6. 2517. So all the petitions, you have no objection. See, the delay is for 563 days.
Yes, sir. No objection. That matter is already lordship delayed. Matter has already been delayed, Lord.
2519 আছে ন? একেখিনিয়ে লিখি দিবা। Parties. Two, 3, 4. Para 2, 3, 4. In case. So what about now that respondents, all the respondents have been substituted now. 5A to 5, all this A, B, C, D, 6, D, so many respondents have been substituted in place of 5. So now what to do? You are not representing the legal heirs of 5.
Yes, sir.
You're not representing, no?
Let them file. I don't know why they have no objection because.
So then we will list it for orders only. We list it for orders. You issue notice to the respondents
They
then.
should file a Bhakaratnama, my lord. The matter will be end. If they appear for all other respondents.
No, now you'll have to file, that's, they are substituted. Now in this main case, you'll have to file an amended plaint.
No, then if they have
Not amended
received,
plaint, sorry,
if they-
amended petition.
no, if they have received, it will be expert against them.
No,
Five
but for,
ABCD.
after substituting the matters,
Yes, my lord. If
the
they have received,
substituted heirs have to be filed, no? The legal heirs, their names have to be filed, that amended petition has to be filed. There's a revision petition, isn't it? You'll have to file the revision petition, then we will proceed. You file the amended petition.
Matter needs for lordship order.
It will come for orders only. It will liquid here. Main case of liquid. as petitioner, Miss Learned Counsel, Mr. R. Goswami is present on behalf of the petitioners. Learned Counsel, Mr.
M. Borolo.
M. Boro is present for the respondent number 1 to 6 and for the respondent number 6 to 8. Void orders dated. It void orders dated nalage. To with IA likhi dile ho jabo. The legal years of respondent number have 5 has already been substituted. An amended petition is to be filed with the newly implemented legal errors of respondent number 5. List after 4 weeks.
The interim passed earlier may continue.
Where
Here in the CRPIO 56.
interim order shall remain in force till the next date of listing.
28.
Come on, very lahla koi thik ba time like bagan paragraph bola banana ase.
This matter has become infectious. It can be disposed of today.
This matter 28.
Yes.
Your Worship, I'm not a petitioner.
Just
We had filed a CRPIO on 4/10/23, and that we had filed a CRPIO 379 of the 2023 for the early hearing as well as disposal of the title appeal number 19A of the 2016.
And the hearing has already been commenced in the learned ADK number 2. On 15 to 25, the matter
Lordship.
was heard part.
Your Lordship, your Lordship, the thing is, apart from 5/2/2025, for the last previous dates that has been allotted by the additional districts number 3, they have been given the ground or adjournment on the basis that the learned council is out of station. Only on 15/2/2012 they had done the part hearing. So, your Lordship, since the service has been completed and sole respondent has been represented today, let the matter be fixed for admission hearing.
Lordship, it would be a
But
futile
hearing has been
exercise.
taken up.
Yes, it has been taken. 15 to 25, the hearing was commenced. Part heard. It has
Then, Lordship, our prayer is that to direct the learned appellate court to dispose the matter within 1 week, within 1 month.
Why?
Your Lordship, for the last previous days, apart from 15/2, they have been taking time on this matter on the ground of the absence of the learned council.
But we have duly done our part on 15 to 20. And even day after tomorrow, the matter is fixed. 13/3/25, the matter is fixed before the learned ADK.
This title appeal, the hearing
Title
has
appeal,
been taken up.
yes.
There is an execution pending also.
Yes.
Yes, Your Honor. Yes, Your Honor. Your Lordship, our prayer is that apart from 15/2/2025, they have been taking time, and the court has granted them time for all the previous days on the mere ground of the non-presence of the council as they for ill health or he is out of station. Only on 15/2/2025 they have the part hearing.
But the Lordship, the fact remains that in the meanwhile, the council has already also been changed.
Your Lordship may dismiss the matter today, but Your Lordship, a direction may be passed to dispose of matter within 1 month because as per their conduct on previous days, they may take.
We'll keep it pending. If you're so much worried, we'll keep it pending.
It would be a futile exercise because
Let it remain pending. Next day we'll pass an order. Because he is saying that on
They have
this
to-
ground or the other ground you have been taking
But we have,
adjournments.
Your Lordship, we have Your Lordship, as per we have the records of all the previous days, and it is clearly evident that they have been taking time, and they have on the mere ground.
See, you are mentioning 2025 from December. I'm not getting track of the dates also.
Your Lordship, may the matter be fixed for orders. And then on the next
Let
day,
it remain pending.
and on the next day, we can give on the list of the dates that have been passed where they have taken.
Yes.
Where they have taken the
Yes.
ground of absence
Yes.
on the absence
Yes,
of land council.
yes. List this matter after 4 weeks.
Yes, sir.
List this matter after 4 weeks.
Public.
Item 29.
That is a lot. Lordship, on the last occasion on 1/4/24, it was directed to take steps on the respondent. It was directed to take steps on the respondent, and we have taken the service complete.
Learned counsel for the appellant is present. Service report on the respondents is respondent 1. Service report respondent is awaited. Issue not reminder to issue reminder to for the LCR. List after 4 weeks.
Lordship, kindly fix the date.
Later date.
On 22nd April.
List on 22nd April.
Obliged, Lordship.
Item 31.
Maybe. For the notice of the respondent number 12 is office notice silent. I have taken step long back. So for the respondent number 1 is concerned, brother is activated.
We'll await then. We'll await. Or you want to take fresh steps?
That may be my lord, lordship. It is up to you, lordship, because my lord, office order is silent. So for
Then we'll wait. We'll wait. We have taken steps, no?
I have already taken step.
We'll wait.
My lord, perhaps it would be better if the registry is directed to provide an office note on the next day regarding the service status of respondent number 12.
It will be better.
That will be better.
LCR also not called for. Reminder may be
Healthcare is not
Okay.
received. Yes.
Learned counsel, Mr.
MP.
M.
Case on.
MK Sharma is present for the appellant, and learned counsel, Mr. D. Chakraborty is present for
Only
Yes.
one.
respondent number 1. It is submitted by the learned counsel for the appellant that the office note dated 5/11/2024 is silent about the service of notice to the respondents. The office may reflect the status of notice issued to the other respondents number 2 and 3. 2 and 3. LCR is called, trial court record as called for is not received. Issue reminder. List the matter after 4 weeks.
Lordship, please, my lord, a date may
Date.
Fine.
4 weeks.
Fine.
All right. All right. All right. All right.
Please, Lordship, as per office note dated 28/8/24, the notice has been served upon all the respondents except for respondent number 8, and the LCR has also been received. But your Lordship, in the connected I for condemnation which was filed and subsequently been allowed, the respondent number 8 has appeared, and we have
I will appear for it.
So it will
Learned
be-
counsel, yes, we will, it has been admitted, no?
Yes, sir.
Appeal is admitted. We'll fix it for hearing.
Yes.
LCR has been received, no? We'll fix it for hearing. Learned counsel means
B Rai.
D. Roy.
B Rai.
D. Rai is present for the appellant. Learned counsel Mr.
C. Sharma, Lord.
C. Sharma is present for the respondent number 1 to 8.
No, Lord.
Respondent number?
I am for respondent number 1, 5, 6, 7, 8, and 9.
1, 5, 6, 7, 8, and 9. Learned counsel Miss D.D. Bhuya, no? D.D. Bormon is, Mrs. D.D. Bormon is present for respondent number 2 and 10. So everybody is present.
3 and 4.
3 and 4.
Revenue Department.
Revenue Department. Revenue will be represented by the government advocate, no? Standing counsel. The respondent number 2 and 2 and 10, 3 and 4 is not represented, no? respondent number 2 and 4 is not represented, but notices have been issued and served.
Yes, it has been duly.
The office note dated 28/8/2024 indicates that notices have been served to all the respondents. So we will fix it for hearing then. LC has received, list this matter for hearing. If it's usual course. Usual course?
Item 33.
May please lordship. This appeal is appeal, regular first appeal.
Hmm.
And it is admitted. Into notice and appear.
Readings are complete, no?
No, Lordship, I am appearing for all the parties except respondent number 4.
Respondent number 4 is, my lord. Respondent number 4. Rajat
No.
2D. There is no 4, respondent number 4.
It is Neha Jain. It is 4. Neha Jain.
I do not know where. I have not made Neha Jain 4. My claim,
We have respondent number 2 or 3.
yes, one is the my lord.
These are the legal errors, no?
These all are legal errors. They are the brothers and only the mother of this farm. They are representing all.
No,
Respondent number 1 is the firm, respondent number 2, A, B, C, D.
Yes,
Are the you are representing Neha Jain. Neha Jain is respondent number 2C.
yes.
yes, I am not appearing for them.
Neha Jain.
I am not.
You are appearing for
All other parties.
My 2C is my lord, and you see, he's staying in Dubai. So, 2D, my lord, next page 4, that is for self and as an attorney of 1A to 2C. That means Roger Join is appearing, they have given the power of attorney. So, service is complete.
So I am not aware.
I do not-
But I am appearing for the rest of the parties, not respondent number.
Otherwise,
Yes,
service is
that you
complete.
can affirm for whom you are representing.
And I have all other parties except this 2C. I am not appearing.
2C. Neha Jain.
2C,
I am not.
2C is my lord, otherwise not necessary.
If he wants to delete, he may delete it.
Will you
Maybe
take,
up to
my lord, these things is already 2D representing the 2C. I do not know,
No,
it is
it
clear
is-
in my cost title. And even then,
He is denying. No.
my lord, I have written this cost title. Last set of appeal before this honorable court, they have filed the appeal. They have given this type of cost
My
title.
Lord said that time she
What
was
for
not
now?
married. Now she is married. She has gone abroad.
That is why.
I am not. I am no
Yes.
special. Lord. That.
No, 2C. There is nothing, my lord, reflection in the office note regarding 2C. I have taken the step because I have taken the step to this 2C because it's abroad.
So Lord, all office will be directed to give the status of 2C. That will do.
And in the meantime, my lord, case is,
The office will never be able to give status of 2C.
there is no office note even then regarding a service of notice. Kindly,
Because here it is mentioned into this
it is very important, my
that
lord.
Rajat Jain is
Yes.
the power of attorney,
Yes.
attorney holder of 2C.
2C.
Lord said, not now. It was previously sometime. I don't know because I was not in the trial court. But I am
Not trial court, in the High Court, they filed an appeal. That appeal was after
I was
hearing,
not there. I am
remand
not-
back to
I
the
am not
Nogao.
instructed.
Nogao. Then I come here. This case is proceeding 1996, my lord. It is a case of 48 lakh, not a single penny has paid. So he paid
Lord, say,
50%.
Just let me submit.
It is my privilege because I am the
It is your
appellant.
privilege.
It is I am the appellant. You take instruction, you file my landed parents file this Okalatnama long before. Because he very tactfully filing the Okalatnama and taking no. I'll look after the matter. Things is that it is 1996 case. 3 times comes in the High Court. but not a single money is paid to me. Again, my lord, it is remand back in the last year, 2023. Then we appear, they did not appear, whatever maybe, I'm not bothered for that. Then again, judgment is delivered in favor of me. Then I filed in this appeal in regard to the interest, part of interest, as per Interest Act, because our interest is 19.25%.
No, but see,
And regarding my lord,
they are denying he is denying this, in the first instance only he is denying this.
they are always denying. They are always denying.
No, he not that. He is denying that he is the attorney holder for to respondent number 2C.
I don't know, they take the instruction, then after 1 week, 10 days, again receipt. My lord. Otherwise,
Okay then.
fixed on another date,
Lordship,
date.
I have checked the record. They have not sent notice to Dubai. They have sent notice to Calcutta.
That is why, because
And here
representative-
Because you
in
got
court-
the attorney holder.
they are attorney holder.
Lordship, previously, some other counsel used to,
No.
Mr. Deka used to appear previously. I am appearing at a face.
But
And so far, I am
one
concerned, I have
time,
no
my
instruction.
lord, during proceeding, last 30 years, one time you file an appeal before this honorable court saying one power of attorney, I'm appearing all the respondents, all the appellants. Now you are saying, I have written, because it is on the record. I have written in on the basis of the record. I am not getting my own.
Lordship, I am submitting on my own behalf. I am not submitting on behalf of any party.
That is why, my lord, I'll show this, my lord, to power of attorney. I can show this power of attorney. That is why it give a, my lord, our thought
All
date,
right, okay. All right.
because it is a matter of money. They filed an appeal last time. Now, after hearing 10
You,
years,
why have you not annexed the power of attorney in this?
well, I'll show you next time.
You have
They filed an appeal by writing this power of attorney. On a power of attorney also annexed
learned counsel, Mr.
RC
R.C. Pal is present for the appellant. Learned counsel, Mr.
BKJ.
B.K. Jain is present for respondent number.
All except 4. All except 2,
3.
all except 2.
Respondent number 1, 2A, 2B, 2D, and respondent number 3. The learned counsel, Mr. B.K. Jain, is not representing respondent number 2C today. On the other hand, the learned counsel for the appellant has submitted that the respondent number 2D is the attorney holder of respondent number 1, 2A and 2C, and the respondent number 2D can also represent the respondent number 2C. Also, however, the learned counsel for the respondent number 2D has denied,
No, I have no instruction.
has submitted that he has no instructions if the respondent number 2D is the attorney holder of respondent number 2C. List the matter after 3 weeks, 2 weeks.
My lord, last week of my lord,
List the matter on the next week.
my lord, 20th of yes,
After 1 week.
It may come in the first week of April. Lord.
no, 20th of, it is
28th.
List the matter
20th
on
of March.
28th. Lord.
20th of March.
20th of March.
I will apply this, my lord, over.
20th.
Yeah.
20/03/2025.
My lord, March of March.
Lordship, 28th.
Yes.
28.
28.
Okay, 28.
March of
34.
For the applicant. Notice has been served and LCR has been received. Kindly list the matter for hearing.
Learned counsel, Miss
Aspal appearing on behalf of Mr. A. Biswal.
Aspal is present on behalf of Mr. A. Biswal representing the appellant. Appellants. Office note dated 28/8/2000. 24 indicates that records have been received. But there's nothing about notice being served. Notices have been issued, but service report on the service report of notice on the respondent is awaited. There is nothing.
They have already appeared. The Wakalatnama means the name has been shown of the respondent.
Okay.
That was this.
Okay.
It's Misra, I think.
Last of the how many respondents?
Sole
Sole respondent.
Sole respondent.
Sole respondent.
The learned counsel, Mr. A.K. Mishra's name is reflected in the cause list as learned counsel for the respondent. List the matter for hearing.
Hello.
बाकी नहीं notice to the service report awaited ना लगे. LCRs received to लिख दी. List the matter for hearing in its usual course.
Item 35.
In this case, the office note indicates, my lord, that as regards service upon respondent 2, it is silent.
Respondent number 2.
2, madam. Therefore, respondent 1, madam. LCR has been received.
Learned counsel Mr. S. Count is present on behalf of the appellant. Learned counsel Mr.
BB Kapoti.
BB Kapur is present for the respondent number 2.
What?
1. Respondent number 1. It is submitted that the office note dated 23/1/2025 is silent of service of notice to respondent number 2. However, full stop. However, LCR is received from the concerned district court. Office to reflect the status of notice which has been issued to the respondent number 2.
Copy of the
This-
appeal and the appeal I have already served to post. I'll hand them a copy.
Appellant may furnish copies of the appeal memo to the respondent number 1 during the course of the day or within 2 days.
Within 2 days.
This after 4 weeks. Like even day.
Item 36.
It's a transfer petition. Both sides their name is showing, my lord. The respondent's name is showing in the cause list. We may fix it for admission. Transfer for divorce suit from Vishwanath to Nogam.
Learned counsel Mr. S. Nawaz is present for the petitioner. The name of the respondent's counsel is reflected in the cause list. List the matter for admission.
Is an interim order.
Hmm?
Is an
Interim order also. Any LCR has been called for?
No, madam. Transfer petition.
So 4-5 cases, no?
Yes, madam. There are 3 cases pending in Nogam.
So no LCR has been called for. Okay. Interim order shall remain in force till the next date of listing.
Come deeply.
List after 4 weeks.
Come deeply. Okay.
Item 37. Item 37.
For which respondent?
Respondent number
2. The appellant is not represented today. Learned counsel Miss
J. Boyster on behalf of Senior Counsel Mr. Ankita.
J. Boysa is present on behalf of Learned Senior Counsel Miss
Mr. Ankita.
Mr. N.C. Das, representing the respondent number 2. Notice issued to the other respondents is awaited. List after 4 weeks.
Item 38.
Yes, yes, yes.
And for the respondent lordship, the matter may be fixed after 2 weeks.
In the meantime, I have no objection in them. Her senior is not there. So, but in the meantime, the interim may continue. Interim.
Learned counsel Mr. S. Sharma
Yes, sir.
is present for the petitioner. Learned counsel Ms.
Okay, doctor.
A doctor is present on behalf of learned
Sharma.
counsel. Huh?
MP Sharma.
Learned counsel Mr. MP Sharma, representing the respondent number. Sole respondent.
Sole respondent.
Representing the respondent. Is this matter after 2 weeks? Interim order shall remain in force till the next date of listing.
Item 39. Item 39.
Yes.
But this is an appeal for our condonation of delay of 215 days was not allowed. So we are filing.
What? Sorry?
Our
Okay,
condonation
okay,
of
appeal
delay-
against, it is
Yeah.
not allowed. So you have recorded an
Yeah.
appeal. Issue notice.
Yeah, it's not.
uh, Learned counsel Mr.
IS Majumdar.
IS Mazumdar is present for the appellant. Stop appellant to take steps to issue notice to the respondent. How many respondents?
Only one. Full.
Respondent returnable within 4 weeks. List accordingly.
Item 41.
If I may, my lord, the office note reflects that the service by usual process has been completed on respondent number 1, 2, 3, and 4.
Mhm.
My lord, again, the office note dated 10/6/2024 shows that the trustee service has been completed. To that effect, we have filed an affidavit. However, my lord, the respondents have not.
Learned counsel Mr.
GMTS.
G. Imtiaz
Yes.
is present on behalf of learned counsel Mr.
Iqbal.
A. Kaur.
Iqbal.
A. Iqbal, comma, learned counsel representing the petitioner. The name of Mr. Jesse Chaudhary is shown in the cause list as learned counsel for the respondent. Office note dated 1/3/2025 reflects that notices have been served on respondent number 1, 2, 3, and 4. 1,
Yes,
2, 3,
yes.
and 4. But sister, not proper service, but it has been
My
received.
lord, 1, 2, and 3 are living in the same household.
Okay, 1, 2, 3, and 4.
Yes. My lord, respondent.
Any other respondents?
No, my lord, only. My lord, there is an interim. Passed on to me.
LCR has been called for?
No, my lord.
What is this petition for?
My lord, this petition is filed against the impugned order dated 29/1/2024 in Mistake case, the number 141 of 2020. My lord, this application was filed under Order 14, Rule 2, for framing of preliminary issues. My lord, a suit on a similar ground was filed. My lord,
Just, sorry?
in the cause list, my lord,
Yes.
no name is shown for the respondent. Chaudhary's name is shown in item 40.
Oh, okay.
Yes.
Okay, to cut it doesn't. Yours is item 39.
41.
41.
Yes.
Jesse Chaudhary to cut it just. Okay, yes. We'll have to wait for them to be represented.
My lord, a date may be fixed on the first
This
week
this
of
matter
April.
after 2 weeks, 3 weeks?
My lord, in the first week of April, because my lord, the petitioner is beyond 90 years of age.
Okay. List this matter on 4th April.
Yes. My lord, for admissions, my lord. In the meanwhile, they may appear. As my lord, the service is complete.
Maybe the LCR may be required.
My lord, if your lordship deems it fit, my lord, LCR is fine.
Let me just check.
Yes.
LCR will be required. Preliminary issue. It's a small record. We'll call
Yes.
for the scan
Yes.
copies of the
Scan copy.
LCR.
Yes.
We'll not call for the LCR.
Yes, ma'am.
Suit is stayed,
Yes.
but we'll call for the scan copies.
Yes.
Call for the scan copies of the LCR of TS number 46 of 2022. As notices have been served to the respondents, all the respondents, no?
Yes.
Please this matter for let the LCR come.
Yes.
Now,
My lord, interim may be continued.
list this matter after 4 weeks.
My lord,
This 4th April. It admission of nalage as the it nalage, huh? Interim order shall remain in force till then.
deeply offended.
Item 42.
Wait, Lord.
Hmm.
In this case, I am praying for stay of the decree.
Hmm.
Matter has already been admitted. What if, can it be taken up on Thursday?
Huh?
Can it be taken up on Thursday next? This Thursday?
Thursday can be taken. Yes, we'll take it up on Thursday. As agreed by the learned council for both. Huh?
13th.
Both the parties are represented.
Yes.
Learned council for both the parties list this matter on Thursday, DDS on Thursday, 13th.
Obliged.
43.
The applicants are not represented today. Learned counsel Miss A. Saha. R. Saha is present on behalf of Learned counsel Mr. B.J. Mukherjee representing the respondent number 1. Is this matter after 2 weeks? For interest of justice, list this matter after 2 weeks.
Item 44.
This is the IA file for the stay of the operation of the impugned order dated 3/2/2024. Last sufficient notice was being issued and other party also names appear in the cause list. In this case, your lordship, in the meantime, an order has been passed by the lower court. This is the order where tremendous pressure has been put upon the petitioner herein to submit their dues that has been not has been paid by him. Even then, he has been paying 10,000 per month. He has been asked to pay 15,000 per month, whereas his income is only 30,000. He has just a small stall of a cloth, and he has been asked for half the amount to be deposited in the court. He has so we have come before this court to just, we are not denying that we will not give anything. We are ready to give, but 15,000 of the total salary of 30,000 is not possible for him. So for his facing tremendous financial crisis. Now, lordship, the order here also says that action will be taken against the finisher on the next day, and adverse order will also be passed. There every chance that order adverse order will be passed. There is no stay order from the High Court, and the next date has been passed for giving an order for passed by the Honorable High Court in the date fixed on 18/3. The assets and liabilities were also been submitted before the court by both sides. Whereas the other side, other party is also a lady who is a BA pass. She has a living source of income also, where she has been asking for half the amount of the salary of the petitioner. So we are praying for a stay of the operation of the impunity order till the record comes, Your Lord.
This order was filed in title suit.
Yes, it's urging out of title suit. Say what?
Who is the order? Impugned order?
Impugned order, Your Lordship, at page 9.
Please read the order.
Both parties are duly represented by the learned counsel. The instant petition was filed under Section 24 of the Hindu Marriage Act 1955 by the petitioner Rima Shri Paul on 20/08/22, seeking maintenance alimony pendulite cost of the litigation. The petitioner submits that she is the legally married wife of the opposite party respondent. The marriage was solemnized on 13/6/2019 at Tezpur as per Hindu rites and custom. After the marriage, the petitioner was taken to her matrimonial home at Hojai with her husband, and out of their conjugal life, a son was born of them. After the birth of their child, the marriage with the opposite party respondent started to become unbearable for her due to the persistent mental torture inflicted on her by the husband and in-laws. Accordingly, she left the conjugal life with the respondent and did not return to him. Presently, the petitioner is residing in her parents' house along with the 3-year-old boy. It is further submitted that the petitioner has no source of income and is solely dependent on her father for the maintenance of herself and her son. On the other hand, the opposite party respondent is a wholesale cloth merchant and his monthly income is not less than 2-3 lakhs rupees, as he visits every last part of the month either to Delhi, Gujarat, Bengaluru or other parts of India for placing orders of the clothes via air transportation. The petitioner needs money to contest the present litigation. Therefore, the petitioner prays for monthly maintenance of rupees 20,000 only for the herself and her baby, and further prays for providing her expenses for defending the present proceeding initiated by the opposite party. Notice was issued to the opposite party respondent, which was duly served on him, and he entered his appearance and filed his written objection. In the written objection, the respondent submits that the petitioner is not entitled to any relief as the petitioner failed to adjust in the matrimonial house without any cogent reason, which is the main cause of breakup of their marriage, and all the allegations leveled against the opposite party respondent are false and vague. The respondent opposite party stated further that he has started a small clothes shop in March 2019 in a rented room, which he has got from the municipality after taking a loan, and earns very marginal profit and manage the expenditure of the house. Moreover, his mother has been suffering many ailments and his father is an old man. It is further submitted that the petitioner left her conjugal life with him on her own sweet will, as he was not eager to participate in the household chores and used to remain busy on her mobile phone. Under the facts and circumstances, the opposite party respondent submits that the petitioner is not entitled to get any type of monetary relief from the opposite party respondent. However, the opposite party respondent is ready to pay some money for maintenance of the child. It is mentioned here that both the parties have filed the affidavit showing their respective assets and liabilities. After hearing both the parties and going through the case record, I find that it is admitted fact that the petitioner is not earning any money right now, and as such is not able to maintain herself and the baby. And the difference in contention is the petitioner claims that the opposite party is earning monthly at a rate of rupees 2-3 lakhs, and opposite party denying the same contented and the monthly income in around 35,000. However, the respondent has admitted that he has a clothes store. In the light of the aforesaid facts and circumstances, the material available on record, I find that rupees 15,000.
All right.
Yes.
Yes.
Now he has also paid 30,000 for the litigation costs also. Moreover, he has been paying 10,000 every month. 15,000 is beyond his reach. He cannot give. Matter is fixed on 18th. Your Lordship can kindly turn to page 40 of the main civil revision petition, also the assets and liabilities given by the Rima Paul, the opposite party hearing respondent.
You have come against this order, no?
Yes.
You have preferred a revision petition against this order.
Yes.
3/2/2024.
Yes. That is pending. The I is for the stay. She is a highly qualified lady. In the assets and liabilities at page 40, annexure 5, she has mentioned herself that she is BA pass.
BA pass is not highly qualified. What will a girl earn? You give me example any job. What will she get?
According to the petitioner herein, she has been working in a private shop.
How much will she get in the private
He is
shop?
earning around 12 to 10,000 monthly, and he is also ready to give some amount for the child. He is not denying the fact that he will not give. But 15,000 and exerting pressure on him is completely unfair on his part that he cannot give. His salary, he is given his monthly, his tax documents also have annexed herein. His expenses he has annexed herein. His statement of the bank account has also been given before the court. All has been revealed that only 30,000 is his income monthly, and out of that 15,000 is beyond his reach to give 50% of the income to the wife, whereas he has to maintain himself. His old
When
age
is the next
salary
date fixed?
is fixed on 18th of March.
Okay. Let the other side be represented on the next date. If nobody turns up, then I'll pass an order.
But Lordship,
A short date within 1 week. Within 1 week. Hard learned counsel for the IET লিখিবা হা দুটাতে মিক্স করে লিখি দিবা hard learned counsel for the appellant stroke applicant. The name of the learned counsel for the respondent stroke opposite party is reflected in the cause list. Reflected, no, in the
yes,
cause list.
yes.
List this matter on date that diason after Holi. No. Pretty much not. 17 March or DD. I'll pass an order. Interim order if not represented. If other side is not represented, I'll pass an order.
We have to again put the order in the lower court below on the 18th. It will not be possible to get the order in the same date.
17 March, no?
17 March. We'll get the order on the 18th March, and this will not be possible for giving the order in the Sunitpur stage 2.
No, you can send an order. 17, 16, khula ase nahi. Khula bond ase. 13th I cannot fix. It will be 17.
Because Lordship can kindly pass an stay order in this case.
No. I'll pass on the next date. Not today.
17.
Yes, 17.
Oblige.
Same day will give you a copy of the order.
Oblige.
This matter I am waiting for respondent number 10.
The applicant is not represented today. Learned counsel Mr. N.I. Khan is present for the respondent number 10. Office note dated 11/2/2025 indicates that the respondent number 2 and 10 that the learned counsel for the respondent number 2 and 10 have submitted or have filed wakalatnama. Notice issued to respondent number 1 has been returned with remark within inverted commas left full stop return to sender full stop inverted commas close. Service report on the respondent number 3, 4 and 9 is awaited.
Mr. S system is appearing for 3, 4.
3 and 4.
Yes, sir.
Oh, where?
3, 4. So it is reflected in the cause list.
Cause list, okay.
3,
Given
4, 5.
item number, which is the item?
40.
45. Okay. Nalagi to all the responses are represented, I think,
3, 4.
because the others are minors.
Yes, 5, 6, 7, and 8 are minor. 3, 4 represented.
It কাটি দিয়া the all the লিখি দিয়া office note dated office note no cause list লিখি দিয়া the cause list reflects that all respondents are represented by the learned counsel. All the respondents are represented by the learned counsel. However, full stop. No, the cause list reflects the names of the respondents of the names of the learned advocates for all the respondents.
Respondent number 1. For respondent number 1 is nobody.
Okay. Names of advocates of the respondent number 1, 2.
2 is appearing.
Respondent number, you are for 2?
No, I am for 10.
10. Names of the respondent number 2, 3, 4, 5, and 6.
5, 6, 7, 8, 10.
না হেতু নালাগে নালাগে 72 হেৰি মাইনৰ হয় নালাগে ও মাইনৰ
Represented by 3 and 4. So 3 and 4 is appearing here.
Notice issued to respondent number 1 is received is returned without service with remarks left with inverted commas left full stop return to sender inverted commas close full stop. This is matter after 2 weeks. Applicant has to take steps to issue notice to respondent number 1 because that address is not proper. So we'll receive after 4 weeks. 2 weeks. 2 weeks or 4 weeks? 2 weeks later. 2 weeks later.
Item 46.
May it please your lordship. Lordship, here in this case, I am for the claimant. And through this application, I am praying before this honorable court for a direction to allow me to withdraw the amount deposited by the insurance company respondent number 1.
I'm for OP number 1, and we have no objection to withdraw that.
Third Miss
D. Devi.
D. Devi, learned counsel for the appellant stroke claimant.
Claimant respondent number 1.
Claimant. Learned counsel for the claimant stroke respondent number 1. Third Miss S. Soikia, learned counsel for the
OP number 1 in the IA.
OP number 1. That is the insurance company.
Yes.
That is IE, the insurance company. Through this application 4014.
4014.
Through this application, the applicant stroke respondent number 1 stroke claimant has paid for withdrawal of 50% of the 50%.
50%.
50% of the awarded amount.
Lordship is 25%, which we have already deposited.
You have deposited only 25%.
Yes, sir. As per the order of the honorable court, we have deposited 25%.
Only 25%. 25% of the awarded amount of rupees
16,10,629.
The learned member of MST Sunitpur in MAC case number 25 of 2021 has directed the insurance company to pay 25% of the awarded amount. No, 25% no. Has directed the insurance company to pay an award of rupees 16 lakhs. How much?
No, Lordship. Lordship, total Amount is 55 lakh
55 lakhs
66,780.
Against that award, we have filed this appeal.
That is not required. 25% to lease level also it would not eligible, huh? Has directed the insurance company to pay rupees 55 lakhs. Please repeat once more.
55 lakh 66,780.
In favor of the claimant. Full stop. The learned counsel for the insurance, appearing for the insurance company has no objection if the claimant withdraws 25% of the awarded amount. I have considered the submissions. Full stop. The claimant stroke applicant is allowed to withdraw 25% of the awarded amount deposited before the register of this court. After proper verification of the claimant by the registry. And subject to the condition that the claimant executes a bond or not required,
There is no
subject to
requirement.
condition. Or main case to लिखिए, please this matter. Pleadings are complete.
Pleadings,
Have you received the LCR? Let's check. LCR पाइसो no? Cause for the LCR, pleadings are complete. Learned counsel Miss
D. Devi.
D. Devi is present for the claim for the appellant. Learned counsel Miss
Lordship, I am for the respondent number 1, and she is for the
Learned
respondent.
counsel Miss SOK is present for the appellant. Learned counsel Miss D. Devi is present for respondent number
1.
Anybody for other respondents? Service report on respondent number 2 and 3 is awaited. Is this matter after 4 weeks?
Lordship, as per the policy, their names are showing for 2 and 3.
46?
Yes, Lord.
Okay. Service report on respondent number 8 cut दिया सुन. The cause this reflects the names of the learned counsel for the respondent number 2 and 3. List this LCR received list this matter for hearing. It was admitted, no?
Yes.
No, not admitted. Oh yes, admitted. List this matter for hearing. In its usual course.
Item 47.
Please, your Lordship. Here in this case also I am appearing for the appellant. Lordship, by this, through this I am praying for a direction from this honorable court to direct the respondent number 1 to deposit 50% of the awarded amount.
Learned counsel Miss
D. Devi.
D. Devi is present for the appellant.
Respondent number 1 claimant.
Respondent number 1, claimant, who is the applicant in this case, and learned counsel, learned counsel Mr.
A. Burman on behalf of P. Hazarika.
A. Burman is present on behalf of learned counsel Mr.
P. Hazarika.
T. Hazarika, represent P. Hazarika, representing the
Number 1.
Opposite party number 1 appellant.
OP number 1, insurance company. First stop. The learned counsel for the applicant has prayed to direct the respondent number 1 to deposit 50% of the awarded amount of rupees. How much?
Lordship, total awarded amount is 14,74,000.
Awarded amount of rupees 14,74,000. First of White judgment and order dated 11/4/2023, the learned member MACT Sunitpur Tezpur has directed the insurer to pay an amount of rupees 14,75,000 with interest of rupees 6% per annum from the date of filing of the claim petition till full and final realization, full stop. The learned counsel for the insurer has submitted that they will deposit the 50% of the awarded amount. Full stop. The opposite party, that is the insurance company, i.e. the insurance company is directed to deposit 50% of the aforementioned awarded amount within 4 weeks from today. From 6 weeks from today.
Lordship,
Yes.
Lordship, after their a direction may be accorded, after their deposition, we may be allowed to withdraw the same.
You will have to file another IA, I think, for withdrawal. Another
Lordship,
IA for
if
withdrawal.
order
Because
is
here
given-
you have not mentioned. Only about deposition you
No,
have mentioned.
Lordship, I have mentioned in the prayer portion.
I couldn't find it.
Lordship, last line. May I read?
Yeah.
It is therefore prayed that your lordship may be pleased to admit this application, issue notice to the opposite parties, an appropriate order may be passed directing the opposite
Okay,
parties.
okay, I got it. Last part. Yes, can we pass an order for withdrawal? As the learned counsel for the insurance has no objection, the petitioner is also the applicant is allowed to withdraw the 50% of the awarded amount deposited by the insurance. From the registry of this court, after proper verification of the claimant. In terms of the above observation, this petition stands disposed of. Both the parties are represented, you know. You have any other party apart from the insurance?
Respondent number 2 and 3.
Have you issued notice?
Notice issue. No. Appellant or Carnival. Respondent number 2 or 3.
Respondent number 1 and 2 is represented. Learned counsel for the learned counsel for the claimant is present. Respondent number 1 and 2 is represented. Service report on respondent number 3 is awaited. LCR is received. Please this matter after 2 weeks. Edu time after niki o ase log pati ekhini 48 49 কিন্তু লব নোৱাৰিম থাকে 48 49 বাকি আছে নেকি we'll leave this matter as left over Item number 53, but I won't be able to take up this matter now.
We have
Only 5 minutes.
We have filed the affidavit of this one today itself. Let it be take along with the case file and come day after tomorrow.
Day after tomorrow is no, not this week. Next week. As agreed by the learned counsel for both the parties, list the matter on 18th.
18. 2 IS where they have filed. Let us have the copies of it. They have not
Yes, yes, you can have the copies.
Lordship, I am appearing for item number 49, Lordship. Lordship, the matter may be fixed next week, Lordship. It's for condemnation, Lordship. 49.
Due to paucity of time, list this matter on 19 March.
Item number 49. 50. Highly
Item
obliged.
50, Lordship, there is a petition for condemnation of delay. Only notices to go, Lord.
Item number 50. Petitioner applicant to take steps to issue notice to the opposite parties. List the matter after returnable within 4 weeks.
Lordship.
List accordingly.
We have not received a copy of item number 50.
Please give them a copy.
Lordship.
Lordship.
But applicant to furnish copies to the, or copies of the application to the opposite parties during the course of the day. Yes.
Regarding item number 48, madam may take after 2 weeks, Lordship. Already talk of compromise.
Learned,
going on.
huh?
Already talk of
Okay,
compromise.
okay.
going on.
Learned counsel for the applicant is present. Please this matter after 2 weeks.